morning, good morning, good morning, amazing Leonard. It's day 11,952, day 11 of the Kouri Richins trial, Utah versus Kouri Richins. We seem to be getting very close to the end of the state's case in chief, but you know what we haven't heard? All the stuff Kouri Richins said to law enforcement. We haven't heard any of that yet. There's a lot of stuff that Kouri Richins said to law enforcement. There's a lot of stuff that she wrote down. There's a lot of stuff that she said. There's interviews. There's jail calls. There's a lot. And that's what I think we're going to see today. Remember, at the end of the day yesterday, the court said that the lawyers were coming back in an hour before the jury to work on what was being redacted, unredacted, what completeness, what was coming in. And this is a big deal for both sides because, again, the prosecution's using Kouri Richins' words against her, and the defense can't introduce Kouri Richins' own statements to benefit her, but they can ask for completeness. So we are going to, we're going to watch the lawyers until they're done. How long will that be? I don't know. They're still going. So they gave themselves an hour. They're still doing it. It's March 10th. It's Tuesday. We got a lot to do today, and the lawyers are trying to figure out what's going on with the judge. Depending on how quickly they're doing this, I might put it at 1.25 speed and see how much we can zoom, but we'll just go to court and we'll see. You guys ready to go to court? Let me know where you're coming in from, what you're drinking. I haven't had coffee yet. I have a cappuccino. I'm ready to go. I'm ready for court. I'm ready to see what Detective O'Driscoll's going to say. Are we going to see Bryceless pants? Pantsless Bryce. Are we going to see Bryce of the no pants today? I don't know. I'm curious to see what happens. Leonard's. Are you ready? Remember, all of you waiting for your miles. We're going to fly when the jury comes in. We're going to fly when the jury comes in. So let's go to court and then we'll fly as we bring the jury. It's going to be a bit till we do that. Hey there, I'm lawyer and legal analyst Emily D. Baker, and this is your go-to destination for live court coverage. I break down the law, the strategy, and the evidence in real time so you know what's happening. No law degree required. So join the law nerds in the chat. They're here for the facts, not and let's get to court. I love that there are people coming in who are like, I just got the app notification. Perfect. It means we are right on time and ready to go for day 11 because we're going to court while the judge does all of the business of being in court. There's a lot that needs to happen today, and we're gonna get to it. Do you know what Dr. B said to me today about this trial? He's never watched this trial. He peeked in on yesterday on something that I was showing him, and he's like, oh, I really like this judge's voice. He has a very nice voice. I'm like, how are you just figuring this out now, Dr. B?
231-500-139.
How are we just getting here now?
And for the defendant present, the defendant is present as well.
The reason the court looks so empty is because the lawyers are doing motions. I bet they haven't even let the public in yet. Oh, it looks like the bailiff was just like, come on in. So. Riri, I agree with you. Nightbot fights on the all caps because I can't read them very well. I love that the judge is like, I need to not spill my water bottle. That's funny. So for those of you that are new law nerds, I have a really hard time with all caps because I can't parse the words right. It's really hard for me to read them. So Nightbot will remove all caps. I know that all caps are just a common form of excitement, but they're really hard for me to read.
Lots to cover. Ms. Nestor, I appreciate the email you sent earlier this morning. Should we start with...
Let's begin.
The O'Driscoll interview.
Okay.
This has been a very draining trial.
Okay.
Yeah, it has.
So this is docket 1163, which is the state's motion regarding portions of the O'Driscoll interview.
O'Driscoll interview with Kouri.
Clarified by docket 1555 and
looks like the judge has a big old water bottle today.
Email of this morning. Let me get there with you, and I left both of those items on my printer. I'll be right back. You can stay seated. Thank you.
I love that he left them on his printer. He's like, oh, I'll be right back. The audience is starting to come into court. It looks like they just opened the doors as the lawyers were getting seated. Remember, the jury had a 1-hour delay this morning so the lawyers could work on this. It does look like the judge has a very full water bottle. As the audience comes in, I'm going to zoom till the judge takes the bench. We've got a long day ahead of us, I am sure. All of these days have felt pretty long. YouTube's also been a little squirrely this morning, so if anyone's having some YouTube troubles, they've been a little squirrely this morning. It's not you. Just refresh whatever you are doing, and hopefully it gets better. Lou Grace asked about the one-way glass. It's a interview room. It's like a witness interview room, holding room. The noise gate on the microphones always kills me. Jen, thank you for the gifted memberships.
To pages 1 to 7.
We are talking about O'Driscoll's interview. They are looking at transcripts.
Value in, or I guess more accurately, under Rule 106, how do pages 107 qualify, explain, or place into context the stuff that follows?
Mainly because he gives the reason why the whole interview is happening, like what he's doing there and why the interview is happening, and from his perspective. And I believe that's important to put the whole interview into context.
We know why he's interviewing her,
ma'am. I don't see there's anything at all objectionable in it, and it does provide a context of how this meeting happened. They're not in the police station. They're in her house. She invited him in. She voluntarily met with him. All of that, I think.
Ladies and gentlemen of the jury, she's so cooperative. She's nothing to hide. She invited them into her living room.
Matters to context, and we're asking that it come in, especially because there's nothing in it that's controversial. And there are things that I think that are very helpful.
Mr. Bloodworth.
Your Honor, there's a distinction between context to the interview and context to particular.
Oh, the judge has like do we think it's a full thermos of coffee? It matches the mug that he has. So it seems to match the mug. We're, of course, we're going to decide what the judge is drinking out of. That looks like a full thermos of coffee this morning. I take that back. That's not a water bottle. I mean, it is a water bottle. I think that's a thermos full of coffee.
To the interview and context to particular statements.
Yep.
And while this
Same
provides
as
context
the mug.
to the interview, it provides no context to kind of any of the 6 individual statements. The interview context can be sufficiently drawn out through examination of Jeff O'Driscoll. I mean, I'll lay a lot of some of that foundation before I introduce any of the statements, and then of course he's subject to cross on that. The other thing is this is peppered with the defendant's self-serving statements,
Right. That's the issue.
The state holds the keys to.
Okay. So we're going to do this one chunk at a time. The standard under Rule 106, and it's not discretionary, it's an on or off switch.
106 is
whether
completeness.
the portions that, in this case, the defendant wants to add to the designations made by the state are necessary to qualify, explain, or place into context the portions of the interview transcript that the state seeks to introduce. That's under cases like State versus Cruz Meza, 2003, Utah 33, at paragraph 14. Here, with respect to pages 1 through 7, I'm persuaded by the state that this context for how the interview occurred will come out through direct and cross-examination of Detective O'Driscoll. These 7 pages are not necessary to qualify, explain, or place into context any of Kouri Richins' statements that follow. Okay, so we're not going to add 1 through 7. Those will stay
He's
redacted.
like, no, we're not doing that. And for those of you asking about Judge M, here's some fun facts about Judge M.
Then we get to pages 29.
First of all, he serves on the board of directors for the Utah Avalanche Center. Second of all, Judge M and I graduated from law school the same year. I told you everyone I know has become judges. I don't know Judge M, but Judge M and I completed law school the same year. Does that surprise me? No. Does it make me feel my age? Yes. Yes. Yes, it does. Yes, it does. Finished law school the same year. I was amused by that as I was trying to look at what the mugs were, but the mugs are not from the Utah Avalanche Center. I will continue to try to figure out what the mugs are from. We did not go to law school together. Trust me, I would have let you know. I went to law school in California, not Utah. But yes, you know, judges under 50. It's a whole thing.
No, sorry, 15 to 16, right, Ms. Nestor?
Yes, sir.
Okay. This is new as of this morning. Give me just a moment. Is it,
Carolyn
did you have a
asked in the
specific
chat
line number or the whole pages?
if Kouri's required to inform her lawyers what really happened. No. And they defend her anyway. Yes. If she told them what really happened, they defend her anyway. If she said, I'm not telling you what happened, they defend her anyway. And if she said, you know, all this other shit except what really happened, they defend her anyway. They have to try to figure out if what she's telling them is good information or not good information. And we have seen defendants where we were like, oh, the defendant probably told the defense that, and that's not true.
Just the redactions that are on both pages, we would like unredacted. So it starts at line 10.
There are no redactions on those pages.
I have redactions on lines 10 through 25 on page 15 and lines 1 through 12 on 16 is the copy I was given.
Your Honor, in negotiating this
Your
back
Honor,
in
no.
whatever, January, the state conceded to her request to unredact that. The state unredacted it. The current copies,
Your
which
Honor,
are
no.
before the court and in the link I recirculated this morning, show no redactions there.
Okay. That's moot then.
Very good. That brings us to pages 29 to 32.
Oh, Mr. Bloodworth. I can't imagine how thin his patience must be at this point. It's exhausting when you cannot trust the representations of opposing counsel. It keeps you on your toes.
So here we have
A
Ms.
different
Richins
way.
making references to Eric going to jail and Cody's involvement in that situation. Ms. Nestor, why is this necessary to
Anything.
qualify, explain, or place into context Ms. Richins' statements in other parts of the
Because, Your Honor, it makes the victim look bad, obviously.
transcript?
Give me just 1 second, Your Honor.
Sure.
We've learned that this is a critical feature of going to trial,
So-
it seems.
Previously, they were talking about whether or not Eric was happy, if he was depressed, if he was suicidal. And as a flow and arc of that conversation, she then goes into the question O'Driscoll asks is, okay, anything else regarding his mental health history? That's line 3 on page 29. She answers, no, not really. But then she goes into, like, there wasn't generally, he had his struggles. He was stressed. And then she explains how he was stressed. So I think or why he was stressed about his relationship with his business partner. I do think that completes the answer to the question. It completes the entire subject matter of the conversation. It's actually evidence that has already come in as far as no longer being objectionable. This all came in Cody's testimony. So we would ask that it be put back in.
So I think you have fairly characterized everything through page 31, line 3. After that, though,
Okay. After that, what?
I think he turns in a different direction. That is not relevant or does not qualify, explain, or provide context for what you just described.
Not
I really
fairly
don't care about the
represented.
rest of it.
Mr. Bloodworth, line 29, page 29, line 5 through page 31, line
I really don't care about the
3.
rest of it as an interesting response to the court.
So we will unredact that portion, Your Honor.
I think it's a fair continuation
Fair.
of Corey's explanation regarding things that were stressing Eric Richins.
Yes.
Okay, very good. So we're going to unredact page 29, line 5 through 31, line 3. The remainder of that redaction stays as is.
Okay. And again, this is
All right, I think then we go
a
to
whole lot of
pages
really important
107 to
legal wrangling.
112.
which is hard for us because we're not flipping along with the transcript.
Help me out, Ms. Nestor. I wasn't quite following defendant's position on this.
Okay.
Help me
just
out.
one
What are we
second here. I'm
doing?
sorry.
Laura Ann asked if I'd ever experienced a defense team similar to this. I have worked with defense attorneys who everything they said had to be double checked. It's exhausting. I have not worked with them in a trial that is weeks and weeks and weeks and weeks and weeks long. It would be exhausting. It's exhausting.
So this, and it's getting hard for me to remember what I know from what happened in the courtroom versus what I know from getting ready for trial, so I apologize.
I mean, that's fair.
I cannot remember if this came in yet. I think it's going to come in with Mr. O'Driscoll if it hasn't already with Chelsea, but there's conversations in here about texts with Chelsea on the day that Eric passed. And it's a continuation of O'Driscoll asking about phone records and him reviewing available phone records. And she goes into what she's reviewed in terms of the calls between her and Chelsea. So I do think it's all part of one conversation.
Really?
And I think to the extent that hasn't come in yet, I think it's going to come in today.
Well, I don't disagree with your prediction about what Detective O'Driscoll might testify to. The task I have to engage with here is whether any portion of 107 through 112, line 9, is necessary to qualify, explain, or place into context Ms.
Right.
Richins' other statements
Under
in
106.
this interview.
Right.
So I think it's a direct continuation of the questioning above it about telephone records and whether
Right.
she has available phone records, and she discusses these records of calls with Chelsea. So I do think it's all one conversation.
Can you point me to specifically? It seems to me that in the preceding pages
He's like, yeah,
they're
no.
talking about what phones she had access to during what periods of time, when those devices were or were not available to her, which belonged to C&E, which belonged to her.
If you go back just a little further, Your Honor, to page 105, line 15, Detective O'Driscoll starts with, okay, so when was the last
That's
time
me.
before the night of the 3rd that you talked to?
Sorry, that was my. You guys still heard the sound, but it looks like the judge is frozen. That was my my monitor froze. It's actually just my monitor's fault this time, which is a new wrong thing. Grammy Bug asked a great question. EDB, can defense introduce things that the prosecutor isn't when it's their turn? Not in this interview. The defense cannot introduce the statements of the defendant unless they put the defendant on the stand. Sorry, my earring got twisted and then it's like bumping into my in-ear. Emily, these are earring problems. Yes. The only solution is more piercings. So they cannot introduce the defendant's own statements in self-serving hearsay unless they put the defendant on the stand and then let, Bloodworth cross-examine the defendant. So the reason that they are arguing over O'Driscoll's interview is because the defense is asking for completeness because the defense wants more statements of Kouri in. They want statements of Kouri couching things. They want statements of Kouri explaining things. They want more of Kouri's words in. But some of it's self-serving hearsay that gets redacted out. And then there's a balance between completeness and what should be redacted out. Let's see. There was one other question. Heather asked, have we heard the judge cuss yet? Yes. The judge was reading a text that said something to the effect of fuck that. He said it really fast, though. Yesterday, he got really close and said, I'm in charge now. And the chat went, those are dirty enough words for me. And away we went.
Chelsea, do you think it was the second? And she says, I think it was the second.
Or no, I'm in control. Was it I'm in control
when
now?
You guys were talking about the
I'm in
anniversary.
control?
Do you know
Or
for
give
sure
me
if it was
control?
the second
Something
or
like
third? Kouri goes into,
I
well,
assumed.
yeah.
I don't remember what he said.
Because actually she sent me all the text messages
Yes, sir.
because they were saying Woody tried to tell Chelsea, which was not true, that Chelsea's the last person I talked to. That's absolutely not true. And that there was some kind of message or something the night of the 3rd. I don't know, but we've pulled all phone records and Chelsea still has messages on her phone. So none of that is accurate. And then it goes into, do you have those records? They were talking about subpoenas. Do you still have them? And then they start redacting her explanation of how she got these texts and basically that she's looked at them and what they say. So I think you're cutting out the second half of that conversation.
Oh, my captions did vanish. Hold on. I'm still reminiscing about the judge talking about taking control.
Which to us
I'll
is
be back.
and we'd like it all in.
Your Honor, may I offer a suggestion?
Yeah.
The state proposes to redact page 105, line 15.
I love that the
all the way down through
solution
107
is remove more
line
of it.
11.
It's like, fine, we'll remove more of it.
Redact the entire portion as it relates to Chelsea Barney.
The judge just
Okay.
kind of smirked with the yes.
That removes the necessity of what follows, Ms. Richins. Oh,
Yes.
sorry, Ms. Nestor.
Yes, Your Honor.
It does, except that I think they'd have to go back further to, because they still have up there where Detective O'Driscoll's basically saying it's weird that your conversations with Chelsea's are deleted. So, I mean, they're just picking the part they like and taking out all the rest of it, right? So they'd have to go back further. If they really want to take out everything about this,
The
it would
bailiff's like,
eliminate my
really?
objection, but they'd have to go back to, let's see.
So why don't we go up to 105, line 3?
Okay, let me look at that.
Sonata, there is not
The
really
state
an
still
age
gets the
limit for
general
judges.
question on page 104 into 105.
There's actually been a few lawsuits over trying to get judges to retire in their 80s, but you do have to have a certain amount of legal practice. So you have to have been a lawyer a certain amount of years. It varies by jurisdiction. You can't be a lawyer for 2 years and then be appointed or elected judge. But outside of that, no, not really.
It just doesn't focus on Chelsea.
That would fix my objection because then it would just take all of it out.
Well, you're,
For example, just so the record is clear, because we only have an audio record here,
Sure.
we have Detective O'Driscoll asking about whether is it possible that things were deleted on your phone? And Ms. Richins saying at 104, line 20, yeah, that's just not possible.
Right.
That
Right,
is
and then he
needed.
gets into Chelsea starting on page 105. So, right, if they would delete from 3 of 105 all through all of it, then that eliminates my objection because then they're not just putting in half of it and not the other half. But
Why'd she
I would
delete
withdraw
so
my
much of it?
objection under those circumstances. But if they want half of it in, I want all of it in.
I'm sure you do.
well, okay, Your Honor, I think we're narrowing in on this, but I don't think we're there yet.
Okay.
I think the defendant raises Chelsea, right, at page 105, line 8. It wasn't Detective O'Driscoll. So I think the redactions should begin
Oh, I see your point.
at
Line 15.
Look, y'all want to make your partners happy? This line right here. This line right here is all it takes. This is all it takes.
Detective O'Driscoll. So I think the redactions should begin
Oh, I see your point.
Oh, I see your point. That's it. That's it. That word. That's it. Oh, I see your point. That's all anybody wants to hear. That's it. Oh, I see your point. That's it. Thanks, Your Honor. We're good. We're going to clip that too.
Line 15.
Right.
She's using recovery of information on Chelsea's phone as an explanation for why she wouldn't bother to delete anything.
Correct.
Okay.
And I think
So
there's
she's
a distinction
misrepresenting
between,
things.
right here,
Is
I
what
think
they're
at line
saying.
15 is the tipping point where there is a statement about deletions,
Right.
and then at line 15 it tips into a discussion about text messages with Chelsea in particular.
That's fine, Your Honor, if you want to start at line 15.
Okay, so we will add the following redactions. We will redact line 105, page 105, line 15 through 107, line 11. And that resolves defendant's request to unredact pages 107 through 112, line 9.
Megan reads
Scott, I
banned
went
books
kind
in
of
the
faster.
chat.
Did you get that?
Yes, Your Honor. We have someone else listening in.
Okay, very good. All right.
Said judge
Anything
boyfriend
further
is
on that,
new
Mr.
book
Glover?
boyfriend.
No, sir.
Fair.
All right.
Fair. Whole different thing. And thank you. A number of you in the chat
50.
indicated that the logo is
107.
Park City High School. The logo is, in fact, Park City High School.
right.
Mystery solved. This makes sense.
That
seeing
brings
he's
us to
in-
page 1.
Seeing that the judge is in Park City, it makes sense that all of the mugs are Park City High School. Wait, do we have children the same age too? That would track. That's not easy stuff.
120. Line 24.
I think the chat is determined to break slow mode today. Thank you, everybody, for gifted memberships. For those of you that are annoyed that you have to wait
121,
to type,
line 8. This
Because of slow mode,
is
'cause we need it.
Kouri Richins giving Chelsea's phone number to Detective O'Driscoll.
thank you, Beneski,
I didn't follow
for the 50 gifted memberships.
how this relates to a prior statement.
The judge is like, how are
Just
we
one
doing
second,
this?
Your Honor, I'm sorry. So all this stuff above that is redacted, right?
Why is no one ready?
Yeah.
Why, defense? The judges, he is going page by page through the email sent and through the prosecution motion from like 3 months ago. And the defense is like, hold on, I need to figure out where we are. Why?
Okay, just a minute, I'm trying to.
Yeah, I'm going to 1.25. At least till we get past the defense chatting with each other about what they want to do with this.
Why is no one ready?
Sorry, I'm getting a little bit lost. Just let me
No problem.
let me look at my notes that I did just one more time. So right now we're looking at the 120 line 24 through 121 line 8.
Please.
Okay, I got it. Just one second. This may not apply anymore now that Chelsea's testified, but let me just make sure.
And that's why they're redoing some of this, because some of it will have changed based on testimony that came in,
We'll withdraw that one, Your Honor.
Okay.
and they withdrew
Then let's
their
go to
request.
page 125, lines 6 through 16. I genuinely don't know why defendant wants to unredact this. We have worked real hard to keep this out.
What is it? Wait, what is it? Wait, Your Honor, did you bring enough for the class? Your Honor, share with us. What are we working hard to keep out?
Yeah, we'll withdraw that one.
All right.
Your Honor, no! It probably has something to do with Eric Richins saying to his friends that Kouri tried to kill him. That's probably what it's related to, because they have worked really hard to keep out Eric's statements to his friends that he thought that Kouri did something to his sandwich to make him sick. So I imagine that that's what it's related to, but that is purely my speculation based on context.
Then we go to page 133, beginning at line 12, and it goes through 141.
Okay.
My notes reflect that this is a discussion regarding law enforcement officers and Cody Wright taking all computers related to C&E and maybe some others, and Cody having access to the garage and office at the Richins home. How does this provide context for Ms. Richins' other statements in the interview?
Just a minute. I'm trying to find.
We're back to just a
Trying to
minute.
see where their redactions start and end on either side. So give me 1 second.
Allie said, love being able to watch this with the law nerds while I take care of my sick 10-week-old. Allie, I am so sorry. It is so stressful when they are that small and sick. And I'm glad that you get to hang out in the chat, but it is very, very stressful when they are so little. And I am just so emo about my kiddos that I'm just going to be like, I remember when they were that small. And now I'm just like, we need to get a medical power of attorney so when you're on tour, the doctors will still talk to us if you clock yourself in the head with a rifle. Again.
Redacted still on the. I haven't seen the newest version. Everything
That's
after
18.
141 is redacted still.
No, there's some unredacted portions beginning at page 167.
Redacted,
The
unredacted.
statement before this redaction that we're discussing is the defendant's statements as it relates to life insurance. The statement after this redacted portion we're discussing is the defendant's statements as it relates to the trust. And the piece that we're redacting relates to collection of C&E computers, which
is a separate
in the
topic
state's view
and
under
not needed
106
for complete.
is not context to either the preceding or the subsequent statement.
133, line 12 to 140.
So the
That
judge
looks
is now looking
accurate
at the defense
based on
going,
my review.
and
I think most of this has come in now, so I'm just making sure that there's nothing.
Music to my soul said a medical POA because he's 18 now. That makes sense, actually. Yes, because especially with him going out on tour with Cavaliers, he has unfortunately had multiple concussions. He does things that put him at risk for concussing again. And we talked to him about it, and we're like, would you like us to be able to talk to the doctors? He's like, yes. We're like, okay, well, then we're going to need a medical power of attorney so we can deal with that. WG Finley in the chat said, I'm confused. Why didn't this happen pre-trial? Something came up. No, this did happen. You are reading the situation correctly. This did happen pre-trial.
Second.
Take your time.
She's almost there, chat. This did happen pre-trial. However, things change during trial. New information comes in. So they are finalizing their rough edit of what was redacted.
That's all come in, Your Honor. We don't need it anymore.
All right.
So what the defense wants in, what they want out. So they are going through each edit and trying to determine if it comes in or stays out. And it is going to completeness. The goal of the defense is to bring in more of Kouri's statements that give context without her having to be cross-examined, right? And the goal of the prosecution is to narrow that down to not let in the self-serving hearsay, but not strip out the context. So they're doing those things. So, yep. Natalie in the chat said medical POA. Yes, my daughter had to have emergency gallbladder surgery at 18. So frustrating without this in place. Yeah, it is. Once they're 18, it becomes much more difficult. So yes, it's something that that is helpful. Even though you are the parents, they are over 18, so they are the adults. So just a level of protection to make sure that it can be, we can help if we need to.
So defendant's request to
not
add
just like-
pages 133, line 12 to 141
We're not
is
just
withdrawn.
yeeting our child out the nest.
Then we fast forward to pages 174 through 184.
Thank you, astronaut 3967 in the chat.
Here, Ms. Richins is talking about the parties' joint account and the flow of money from C&E.
Chrissy, T is
and,
over 18 by like
her real estate
77
business
seconds.
through various accounts.
Right.
The immediately preceding statement is regarding the trust. The immediately following colloquy seems to be about life insurance policies.
Yeah, just a minute. So this is 10 pages. I also think most of this has come in. If you can give me just a moment, Your Honor.
Sure.
All right, I'm going to keep answering some questions while they are doing with this. Judy, you got this. Said I'm emo with you. Meal plans, dorm rooms, etc. I know it's a brave new world. As kids get old, it's great though. Look, I have enjoyed every phase. They all come with their own challenges and their own delights. But my son sends me memes that make me laugh so hard I want to cry is a very fun phase. I'm going to put this at 1.25 until they get back to having a conversation about redactions. And let's see. JW Steed asked a question that I think many of you have had. How can they keep out a victim's statement that he thinks his wife is trying to kill him when he was killed and his wife is on trial? I don't understand. It's hearsay. It is an out-of-court statement that would be offered for the truth of the matter.
That all came in, Your Honor. We'll withdraw that one.
All right.
They're withdrawing that
Finally.
request. That is potentially more prejudicial than probative. It cannot be evaluated on cross-examination. There is a right to confront your accuser. That right is violated when the individual is deceased, and there's no hearsay exception to some of these. We have gotten into some present sense impression. I think the judge kept out more than I might have. I think the judge was overly cautious in that. I think there was room for some more present sense impression statements to come in from Eric Richins to his friends talking about how sick he was feeling over the phone on Valentine's Day. The judge kept some of those things out. I probably would have wanted some of them to come in. It's the more cautious approach. And that's, again, the judge's prerogative. I just would have let more of that in. I'm sure others would have kept more of it out. But it is part of the hearsay rules that those don't all come in. And without an exception, they don't. And especially when it could be more prejudicial than probative, it stays out. It's frustrating. Some of the hearsay rules are really, really frustrating. And looking at it going, okay, so if somebody knows what happens to them and then they die, you don't get to have that come in at court. It depends. All right. Continuing on
Page 213,
with the redactions.
line 25 through 215, line 6. This immediately follows a statement by Ms. Richins regarding Eric knowing about the HELOC and consulting a divorce attorney.
We're at
and him
1.25.
knowing about that based upon statements made by his family members. I'm not sure. Forgive me. I misstated that. It immediately follows a statement by him about knowing about the HELOC. And then Ms. Richins talks about how he knew about that was because his family members told him, and then he went and consulted with a divorce attorney.
Right.
I'm slowing this back down to hear about the HELOC fight.
I do think that's all one conversation, Your Honor, where they're talking about how he I got to go back a little further. They're trying to say what they're accusing her of and how
Murder! They're accusing her of murder, ma'am.
they changed I mean, that's all one conversation, I think. I stand on that
Tell
request.
me why Ms. Richins doesn't
Tell
pivot
me
away
why.
from what Eric knew to what his family members were doing to her.
Tell me why.
There seems to be two different topics here.
Right. It's got to be completeness within the same conversation and the same thread. The judge is like, no. Oh my God, this is taking so long. The judge is like, what are we doing?
Well, I think this is all connected to the HELOC. I mean, Ms. Benson
He disagrees. He just told you he disagreed.
early on
need
in this
more
case
explanation.
that the HELOC was what precipitated the meeting with the divorce attorney. The divorce attorney has also testified to that.
I don't
Right.
disagree with that.
This is Kouri lumping all that together in one conversation with O'Driscoll. So I do think this all should come in context.
I will tell you that
I just
yesterday.
think it's all connected to the beginning of the conversation where they're saying
Emily, hold that story till she's done because
that
there's
he
going to be
was
more
unhappy
pauses.
about the HELOC and that
We know he was unhappy
had
about the
been
HELOC.
meeting with someone about a divorce and that Kouri was unaware of that and that she learned about that later from the family.
You take $250,000 from me,
So
I'm
I
going to be
think that's
more
all
than
connected.
angry.
I would ask that come back in.
You'd be
Mr.
lucky
Blood.
if I was only angry.
Your Honor, the preceding statement, which is the statement the state seeks to isolate, is the defendant's statement regarding what she knew about the HELOC. In the redacted portion, she then pivots to divorce attorney discussion, which is in her statement separate and distinct from the HELOC discussion. It has come out in trial that the two are connected.
However,
But
that
in
doesn't
this
change it
statement,
here.
It is a distinct statement through the course of this interview.
Just in terms of ending that, Kouri Richins.
Chad, I see that there are
Yeah.
kids in court. They are not sitting in the family designated seats. It seems that they are sitting in the rows reserved for members of the public. So it might be that members of the public, because it is maybe spring break or whatever, have chosen to bring their kids to observe court. But I do not think they are family members. But, at least in California, school kids went to observe court on occasion. So it might just be kids observing court. So
It seems that Ms. Richins' sentence that begins on 213, line 22, doesn't actually end until 214, line 2. It looks like maybe she and Detective O'Driscoll talked over each other in that point. It would seem appropriate to end it there and then redact the rest.
the court agrees
So
with the
just to
prosecution on that.
unredact 213, line 25 through 214, line 3.
Agreeable.
Okay. That's the court's ruling, Ms. Nestor.
Understood.
So we're going to unredact page 213, line 25 through 214, line 3.
For any of you having some
Okay.
issues with YouTube,
I
we've been
think
having
that
some YouTube
handles the
issues
parties'
today too.
positions regarding the transcript of Detective O'Driscoll's interview with
Oh,
Ms.
are we
Richins.
done?
Mr.
No,
Bloodworth,
we're
anything
not
else on
done.
that?
No, Your Honor.
Kouri Richins has
Ms.
been in
Nestor.
custody since
sir.
Okay.
May 8th,
So that brings us
2023.
to the jail calls. This was originally filed as docket 1165 by the state. It's further characterized by docket
Oh, we're moving on to jail calls. Jail calls!
1555.
I'm very interested in this.
We're just going to have to go through these one at a time.
Oh boy. Let's do it.
As a matter of mechanics, Mr. Bloodworth, these will come in through Detective O'Driscoll.
Yes, I imagine that's true.
Yes, Your Honor, as a matter of mechanics, and I don't know at this point if we're going to
jury's
introduce them
still
all
out.
through Detective O'Driscoll on direct. In fact, trying to recall. There may be only one or two that I can pin down that we may want to address first, although I think that if we can, we should resolve the whole set of them today, because I can see how it would come up in either redirections and crosses that would could begin as early as today.
All right, let's go through them. So tab well, I don't know if you have the same binder. Let's go 2-69T.
All right, we are going to put this back to 1.25 speed until they're talking about something that's too dense. But at this point, I'm too dense. We are going to go through the jail calls. They are going to go through the jail calls. We've already talked about the kids in court. I mean, I can't go to court and kick them out. It's not my choice to make. So it is what it is.
And
the public's allowed to watch
my main
court.
concern is on page 8, lines
So, I mean, here we are.
6 through 18.
I'm sorry, I'm just pulling it up. Which one are you looking at? Can you give me the number again, sir?
2-69T.
Okay, got it. And what portion are we looking at?
Well,
Oh my
the court's
goodness.
concern, based upon the content of the unredacted portions that the state seeks to admit, is page 8,
Lines 9 and 10?
especially. Yeah.
Okay.
Although,
What's on 9 and 10?
Oh, that's definitely part of it. Well, that's Carmen being in jail, right?
yeah,
No, she's not in here, meaning Summit County Jail.
What jail is she in because she's not here?
yeah.
Oh, well, she's
the
not
only
here.
way was Ms. Richins would know she's
Right.
not there is because
Right.
she's there. Yeah.
Right. Yes.
So, yeah, Your Honor, we can sort of.
That's fair. So the judge is trying to, again, neutralize the fact that Kouri Richins in custody. Redacting out Kouri saying that Carmen is not in the jail with her is neutralizing the fact that Kouri's in custody. And they've really gone a long way so that the jury doesn't make any assumption that, oh, Kouri Richins must be guilty because she's in custody. I think in 2026, it's probably not as many jurors that think that as wouldn't. But some people are going to be like, well, if she's in jail, she must have done something. I mean, but it's a murder case, though. And in a murder case, I think a lot of people would be like, well, she's on trial for murder, so she's probably in custody. Like, it doesn't necessarily mean they proved it, but they do try to neutralize
They
it.
redact line 9 and 10 there.
And that's why they're redacting
we
that.
can even redact 11. I don't.
Yeah, if
Just
we can
to
do
be
9,
safe.
10, and 11. Yeah.
Yeah.
Okay.
What Sarah thinks in the chat shared. My daughter's 8th grade government class went to observe court. They ended up watching a man be sentenced for exposing himself at the public
Nestor, what was
library.
defendant's objection to the remainder of this?
Wild story for 8th graders.
Just a minute, Your Honor.
8th grade's the perfect
So,
age for
Brittany,
that.
From 2
It's a good age to remind everybody that what might seem funny in the moment could be less than funny.
69T, we're redacting page 8, lines 9 through 11.
All right, they're redacting that out. Yeah, they're
I think that
redacting.
was my objection to this one.
Great, moving
Okay.
on.
Let me just make sure.
I would speak at high schools frequently. It's something I have not done since I moved, but I would speak at high schools about stuff that went on, particularly in juvenile, and then reminding them that when you turn 18, like, shit gets real, and even when you're 17, shit might get real, and sometimes even younger shit could still get real. And we had lots of
I think
conversations.
that was it. I think that was the only
about
problem
that.
I had with that one.
Very good.
Wait, hold on.
We talked a lot about social media. We talked a lot about sharing photos, even if they're shared with you. We talked about online safety.
That's Carmen.
Okay.
Yeah.
We talked
that's
about
it, Your Honor.
consent.
That was my objection.
Very good. Let's go to 2-71R.
We talked about what aiding and abetting
There's
is.
only 3 text messages sent from the jail
Oh, I'm
set.
sorry, Your Honor. Oh, never mind. They redacted it. Okay, I apologize. Please continue.
2-71R. These are text messages sent from the jail system. The state seeks to admit 3, right?
They're talking about
Yes.
jail texts.
It's the ones from May 24 at 9:50, May 24 at 10:02, and May 24 at 10:03.
Correct.
Okay.
So We have a couple of objections to this one, Your Honor. It looks like they have made all the redactions that we requested that indicate it's jail-related, so that those have been resolved. However, this is a correspondence between Kouri and her brother, and the brother's asking her, did Eric ever talk about suicide?
Right.
But that's the brother asking her.
That Eric said to her, which would
That
be
doesn't
hearsay.
come in.
Also, I believe the brother's statements are hearsay.
Well, all of the non-Kouri Richins statements are
Are
going to be hearsay
hearsay.
if they're accepted for the truth of the matter.
Right.
So that's
Well,
an
but
issue.
they're specifically trying to admit what Eric said for the truth of the matter. So that's the concern that I have. It's like double hearsay. I know Kouri's statement isn't hearsay, but when she relays what Eric told her, that is hearsay. So that's our objection to this one. Also, we just don't see the relevance. There's no...
Okay, but is it?
You don't see the relevance of whether Mr. Richins ever spoke about suicide.
I don't think either side...
I just gonna back that up because the judge is also just like, what is happening? Same, Your Honor. Same. A number of you have asked in the chat, EDB, when the jury comes in, will you send an app notification? We absolutely will. There's a lot of legal argument that needs to happen this morning. There's a lot. Yeah, we will.
That is hearsay. So that's our objection.
I had to back
this
that
one.
up.
Also, we just don't see the relevance. There's no...
You don't see the relevance of whether Mr. Richins ever spoke about suicide.
I don't think either side is making the allegation that he intentionally killed himself. That's never been said by either side.
I think the state is seeking to prove affirmatively that he did not.
Uh-huh.
So I think we can put relevance aside. It's certainly relevant.
Okay.
Mr. Bloodworth, talk to me about the hearsay. Put the brothers level aside.
Kouri Richins' brother.
It's the truth of Eric's statements to Kouri as related by Kouri. Kouri's level, categorically not hearsay. It's the Eric Richins level.
I love the judge's face was just like, what?
Let me pose a hypothetical to tease out the legal issue. It'd be one thing if...
We're teasing out what now, Your Honor?
I mean, I guess what we're trying to tease out is whether this is evidence of whether Kouri ever heard Eric say it versus whether Eric ever had suicidal ideations.
So I appreciate that distinction, Your Honor. She doesn't quote him, right? It's a generic, this is my impression of generally...
Of my husband.
Right.
Yeah.
Well, respectfully, I disagree. He would always say things like, if anything
Ma'am, shush. You just said it wasn't relevant. Shh. Shush.
ever happened to me, blah, blah, blah. I mean, if they want to redact everything after the word not suicide specifically, then my objection, apart from the relevance, which I stand by, but that would cure the hearsay problem of what he actually said. But they could leave in her answer not suicide specifically, because I don't think that relates to a particular statement.
None of this
It
seems to
actually
relate to a
refers the
particular
absence of
statement.
statements.
I think the opposite. That is what explains her statement, not suicide specifically.
Well, then
And-
then none of it should come in.
Right. The statement is Kouri Richins' statement is not suicide specifically. The remainder of that particular text message is, in a sense, 106 completeness because she is explaining her statement.
Why don't we just instruct the jury that they can't accept Ronney or Eric's statements
For
the
truth.
truth, but they can accept them for the effect they had
On
upon Kouri Richins and let the whole statement in.
Correct, Your Honor. That's appropriate.
Because it's not being offered to show any effect on Kouri Richins. It's being offered to get in the fact that Eric made that statement to her. That's the whole reason this is coming in. And I stand by my objection, Your Honor.
Okay.
And just to be clear, you don't want to admit the statement that Eric told her they'd be set for life if he died.
The judge is slow blinking at counsel. Are you blinking Morse code at the defense going, defense, what are you doing? What are you doing? Don't you want the statement that Eric told her she would be set for life if he died? Sir, you cannot bippity-boppity blink this into their brains. I appreciate that you've gone full I Dream of Jeannie, but you can't make the defense appreciate how this would help them by blinking at them. The judge is just like, he's trying so hard. He's like, work with me, counsel. You don't think it would help?
No.
Okay. All right.
He disagrees strongly. That's funny. Y'all need to stop fighting with this judge and listen to him.
I guess if the statement Eric made isn't true, what relevance does it have, Mr. Bloodworth?
It explains Kouri Richins' statement, not suicide specifically. It is the effect on Kouri Richins to make this, to respond to the question of did Eric ever, whatever the question is, hold on. Did Eric ever talk about suicide? She says, not specifically, and then explains herself.
So
As foundation for her statement, it shows what the effect of Eric's statements on her.
Right. But as we tease this out, it seems that to the extent
He's just
that
gonna say
the
it all morning,
effect
isn't
upon
he?
her was relevant,
Oh boy.
regardless of whether it was true, it was her understanding that she'd be set for life if he died,
Right.
not whether or not he had suicidal ideations. Is that fairly stated?
Your Honor, the state thinks it's both, actually. It is the set for life if he died. It's certainly that, right? But it's also the suicidal ideation part because, evidence will come in that, I think evidence is going to come in that she never believed, she said he would not commit suicide. In other portions of
And at her level, that can come in, right?
Sure, but there's a foundation for that. Why do you believe that?
I think with respect to this particular text exchange, first of all, I don't understand why we need the third one. We work backwards from there. Why do we need her brother saying, just curious, someone threw out a scenario, made me think? That seems to be a throwaway.
Well, I guess it all depends on whether or not DJ testifies.
Well, that would be interesting.
That statement could be used in impeachment of DJ Kouri if he were to testify.
Is this one of the things that's coming in through the state's case in chief or the rebuttal case? Or through cross? My apologies. As yet unclear.
So, yes, Your Honor, let me perhaps resolve, I think, the current tension.
Yeah.
If it comes in the state's case in chief, then I would agree that third statement we could redact. We may have a discussion down the road about unredacting it.
Understood. Okay. So focusing on the first two, I think the correct result here.
We're going back to
stated,
1.25.
Counsel ask for any clarification.
I just can't.
Is
Hopefully
to
that
admit the
was
first
chat.
two text messages with the following
These are
instruction to
texts
the
from
jury that
jail.
they cannot consider Ronnie's statements for the truth of the matter only for the context that they had
Right.
or the effect they had upon Ms. Richins as the listener.
Limiting instruction.
They cannot consider Ms.
Richins' statements of what
Richins.
victim Eric said.
relating what Eric Richins told her for the truth of whether he ever had suicidal ideations or whether she would actually be set for life if he ever died, but can consider it for the effect that
It had
that
on her.
statement by Eric Richins had upon her.
So that's coming out.
On a going forward basis.
Okay.
Can we just get a statement as to what effect that did have on her? Because I don't understand that argument at all. And
She
maybe
thought she would be set for life if he died. It provides a motive to kill him.
Okay.
Mr. Bloodworth, any clarification?
No, Your Honor.
Okay. Any other clarification? Just
I love that the
No, sir,
judge
we just
actually
would like a
slowed it
continuing
down
objection to that one.
to explain.
I don't know what you mean by that.
So I don't have to, when they admit it, I won't have to jump up. I just like,
And you don't, under
Okay.
Rule 103, have we discussed anything further on that?
no, sir.
Okay. Scott,
Yes, Your Honor.
would you initially redact?
I think it not only goes to motive, the set for life, I think it also goes to, was Eric lying to her about him changing his will, and did she know that his will had been changed? I think it goes to a couple of those things, but we'll let them continue. They've got a
Message
long
from
morning of legal
at
motions.
5:24 at 10:03. Just curious. I watched something, etc.
I think it's from DJ.
Oh, I'm sorry. You're right. Threats from DJ. For now,
DJ is not Ronney.
and I can pause for a second if my description was inappropriate.
We are at one point 2.5 speed while they are going through jail calls and redacting or not redacting.
We're tracking it in the back as
No
well.
problem. Sounds
Jail
good.
calls.
Okay. Moving on.
I
That
love
brings
that
us to
they're tracking it
272
in two different ways. All right, we are continuing to go jail call by jail call.
It's 1, 2, 3, 4, 5. 5 text messages from 5/31/2023 at 7:14 to 5/31/2023 at 7:24. I think the relevant part of this, Mr. Bloodworth, is that Ms. Richins saying she hardly knew Hayden Jeffs. Is that the point of this?
Correct.
Okay. And so do we need anything after?
That witness is a witness. We saw their surviving partner come in. That witness had died in a motorcycle collision, and Kouri had called that witness seemingly before Carmen Lauber and asked for pain pills or something. And so this is Kouri discussing that witness.
The 5:31 at 7:22 where she says that?
So that's what they are talking about now.
So you're referring to the last two of those texts?
Yeah.
we can redact those.
Okay.
Wait, I'm sorry. Which ones? I missed which ones you're talking about right then.
Another one wanting their 15 minutes of fame. Oh, God, huh?
I would object to that coming out. I object to this whole thing coming in, but if it comes in, they should all be in.
All right. Tell me why you
Objection!
object.
Objection to all of it. The judge, why? The defense.
I don't understand the relevance of this at all.
So we have testimony
So
that's
why
come
do you
out
want it in?
that Kouri Richins had a telephone conversation with Hayden Jeffs.
Also, the line that was thrown away was another one looking for their 15 minutes of fame.
Regarding the topic
Slowing
of
this back
fentanyl.
down.
Here she's saying she hardly knew him. It's probative of their relationship.
They don't talk about that at all in here, though, about any conversation that
But
she had with
she
him.
talks about hardly knowing him.
So they're talking about it.
Your Honor, we just stand on a relevance objection.
Okay, anything else?
No.
Okay. This is relevant to Ms. Richins' knowledge of or disclaiming knowledge of Hayden Jeffs. And do you want the whole thing, Ms. Nestor?
Yes, I do.
All right, we'll leave it as is, Mr. Bloodworth.
Great.
Yes, sir.
Okay.
Next one. That witness
Tab
was
7.
doing like odd jobs and kind of handyman
Sorry,
work with
270
Kouri on some of the houses that were being flipped per the witness who really didn't want to be there. That was the witness who got the text messages about the dog and the catch pole from O'Driscoll. That's that witness.
3T and 274T and 275T. Mr. Bloodworth, Ms. Shervinick, I am genuinely confused by these in terms of this transaction in St. George and this other deed. And
What are we talking about?
I read them 3 times. I really don't know what they're talking about.
So let me propose this as a way forward.
Yeah.
To date, nothing has come in where the state would use these.
Okay.
I can see a circumstance where
Rebuttal.
the defendant's mother would testify that the state would want to use these texts in impeachment
Or the phone conversation.
or the phone
Right.
conversation.
Okay.
Oh, I can see the
So
defendant's
maybe we
mother
can
testifying.
Just put a pin in these till if and when that circumstance arises.
I
Reasonable.
appreciate that. Any objection, Ms. Nestor?
No, Your Honor.
Okay, very good.
Reasonable.
We will skip 73T, 74T, and 75T for now. Then we go to 2-76T.
All right, I'm going to speed this back up as they are zooming. Well, they're not zooming. I would like to be zooming.
With respect to this one, the defendant objects to redacting lines 2 through 8 on page 7. Under Rule 106. In
That's
the court's view,
completeness.
Lisa making a comment about a corrupt police force is not required to be included under Rule 106. But
That's
Ms.
defendant's mother.
Richins wondering if Detective O'Driscoll didn't relate part of his conversation with her to the prosecutor. That seems to provide context.
It wasn't the corrupt police force comment I'm interested in, it's Kouri's, so I don't have a problem with that staying redacted.
So I think if we just focus, Mr. Bloodworth, on page 7, lines 4 through 8.
Can we do that or no? What are we doing?
I also, Your Honor, while he's looking at that, I did catch on page 7, line 19 and 20. I think that's Lisa reading the information, I'm guessing. And
Lisa is the defendant's
hearsay
mother.
the court's done an in limine ruling on page, line 19 and 20 on page 7. That also, just that one little part needs to be redacted. He later told his friend he thought Kouri tried to poison him. That's been kept out.
Well, that part's come in a couple of times. I think it's the sentence before that's the problem. Because that's part of what the state has to prove, right?
Actually, both of those.
I think they both come in.
Forgive me, have we gotten the detail of
The only thing that's come
ate the
in.
sandwich, broke out in hives, had trouble breathing?
No.
That needs to come in.
That detail has come in, I think, in the context of,
Yes.
well, in Ali Staking's testimony about what they were joking about.
Yeah,
I think it's
certainly
all-
ate a sandwich, had a reaction. Was she that specific? I genuinely can't remember.
No.
We can, hopefully somebody in the back scrambling right now to get that portion of the transcript.
I feel like I'm
I also
scrambling.
think it's come in a text message as well.
There's the June text message, right, where Ms. Richins is, I forget who the recipient of that text message is.
Chelsea Barney.
There you go. Is talking about, they're saying I gave him a sandwich.
Chelsea
on that
Barney's the
day.
friend with the stolen
Right,
house.
it's correct. It's the defendant saying, I was with him when he ate. I gave him the sandwich for lunch. He didn't break out in hives. He didn't use an EpiPen.
That's right. Okay.
The concern I have also is it says he later told his friend, which is Cody or Case, one of
Well, he
those.
doesn't say that, and we've already got testimony that there was a conversation in which he told a group of people that she tried to poison him.
Jokingly.
Well,
This
whatever.
is referring to telling his friend, because his friend was not at that conversation. His friend would be either Cody or Josh, and that's been suppressed.
Yeah, I don't think that.
Y'all, I don't
we
know what
to
has
draw that
derailed
conclusion,
chat,
jury
but
would.
we are currently not talking about what's going on in court. Y'all are gonna distract me, and the ADHD is really fighting for its life to be able to explain all of this. Thank you for reining it back in, because it's real hard on the ADHD. Because again, they're going through some in-depth legal motions, and at the end of this, y'all are gonna be like, Emily, what? Y'all, thank you.
don't think we can risk that, Your Honor. I mean, there's a reason you made that ruling. We should stand behind your ruling.
I am standing behind it. Let's take
Right,
this one
he
piece
is-
at a time.
Okay,
Mr. Bloodworth,
one piece at a time.
line 7, can we please add in, any objection adding back in lines 4 through 8?
Sorry, page 7,
Page
lines
7,
4
lines 4
through 8.
Yeah.
No objection to adding that back in.
Okay, so we will
Add a little
remove
bit
the
more
redaction
context in. Okay.
in 2-76T of page 7, line 4 through 8. Then,
Okay.
Ms. Nestor, what is defendant's request with respect to lines 16 through 20?
Your Honor, all we're asking is at least a Darden's statement, which starts at line 16, and then the next question is, when Eric ate the sandwich, he immediately broke out in hives, had trouble breathing. He later told his friend he thought Kouri tried to poison him. We're asking to redact that whole comment of Ms. Darden.
Mr. Bloodworth, the state's response.
Your Honor, I think the, just as some context here, Lisa Darden is reading from, I think, it's the interrogatories in the civil case. That's why she uses the word question.
Oh,
The
interesting.
important part from the state's perspective is Kouri Richins' response there, ridiculous, right? So the preceding paragraph is necessary for the effect on the hearer. I think
To explain
the
why
court
she's
can
saying what
instruct
she's
around
saying.
any
Makes sense.
any hearsay problem about considering it for the truth of the matter asserted.
Okay. Defendant's request to redact lines 16 through 20 of page 7 of 2-76T is respectfully denied because that information, that Eric ate a sandwich, that he broke out hives, had trouble breathing, later told his friend non-specifically who that is, that he thought Kouri tried to poison him, all of that has already come in through other
Okay.
sources of evidence. That will not introduce any new information to the jury if they were to fail to follow the court's instruction that they cannot consider the non-Kouri Richins part of these conversations for their truth.
Your Honor, can I just also, while we're just making the record, we would also ask that lines 9 through 13 be redacted on the same grounds. I understand your ruling, but I just want to make a proffer that we'd also want redacted. So they're saying they're saying just a few days later, Valentine's Day, Kouri made Eric a sandwich and placed it on the seat of his truck along with a supposed love note. I don't believe that has come in. I respectfully
I
disagree. I
don't
don't think
think
it's ever
that-
come in. He had trouble breathing.
It,
And I just want to make a record on that. But I understand your ruling.
Okay. Let's see. I think that handles 2-76T.
Interesting.
Let's go to 2-77T. Defendant objects
Okay.
to redacting the following two sections. Line 20, page 21, lines 14 through 25. This just seems to be a self-serving statement by defendant that is not necessary to provide context for, or explain any of the other unredacted statements. Why is this necessary under Rule 106?
Page 21, lines 14 through 25.
Yeah.
Let me check and see when they. We don't need that. We'll withdraw that.
Okay, thank you. And then, same exhibit, 2-77T. Please go to page 25. Lines 2 through 16.
All right, we're still going through text
I'm not sure why
and
this is
calls
Rule
for the jail
106.
calls for everybody that's just coming in. Don't
Material
worry.
either. It is
When the
almost
jury comes in, we
entirely
will
Ronald
send
Darden
out-
statements with just Ms. Richins making
That's brother.
non-substantively responsive
We will
comments.
send out a notification when the jury comes in today. They are going through the extensive amount of information that's coming in with O'Driscoll following the rulings that have already happened in the motions in limine, because they went over this a first time then, and they're going over it again now.
Okay, I don't need anything above line 14, but line 14 is the beginning of her sentence that starts on line 17.
Okay.
So we need 14, 15. I don't really care about 16. It doesn't. I think he's talking over her, but 14 and 15 is the beginning of the sentence
This is a
that
call
they
with
start
brother.
with 17.
And what's the problem with lines 17 through 19?
What page?
This is Kouri Richins' statement.
She's saying her mother was telling her, so it's triple hearsay. Is her mom telling her what her mom read about what other people said?
Okay, and then doesn't she go on to talk about that on the following pages?
I'm not sure what you're asking me.
If we don't include lines 17, 18, and 19, we don't know what she's talking about when she says stuff showing that I bought lunch at Mirror Lake, like I didn't make any fucking sandwiches.
Right. You bought the sandwich. I didn't make the fucking sandwiches. Fine, ma'am. You went and bought the sandwiches.
It's context for what
It's not like you can't open a sandwich. Good.
she's talking about.
I don't think any of it should come in. I mean, it's all talking about a triple hearsay statement, and she's addressing it.
It's her making comments about what
He did say I didn't make the fucking
with respect
sandwich.
to the sandwich on Valentine's Day.
It's
That's
her
relevant.
responding to what the triple hearsay statement is saying.
Well, that's fine, but the statements made by other people do not come in for the truth. Her statements are admissible as categorically non-hearsay.
So you're going to make an instruction on this one as well?
I'm making an instruction on all of them.
Okay,
That
I'm
they
sorry.
cannot consider the statements that are made by people other than
Keep
Ms.
up.
Richins for the truth of the matter asserted.
So, I'm sorry. I did not understand that you were suggesting that you're making one instruction for everything. I don't know how they're introducing these. I don't know
I
if they're
can
all...
make an instruction every single
That's
time.
what I'm asking.
Yeah, happy to.
Okay, that's...
It just depends on how they come in. Ma'am.
Any other objections regarding this?
He's like, follow me.
Your Honor, we
Stay
don't
with
think any of
me.
it should come in. We think it's all hearsay. We object to all of it.
You're going to have to be.
We object to all of it. You did this in pretrial motions. You're going to have to be more specific. You did this in pretrial motions. The state narrowed down exactly what they were seeking to admit. Then they filed motions. Then you filed a response. Then you sent an email this morning. And now we're back to, I object to all of it. Obviously. Oh my God.
More specific. Do you believe that
I
Ms.
slowed this back
Richins'
down.
statements are hearsay?
Yes, because
Because I thought it was funny. The judge is like pulling teeth. He's just like, and the way I would crash out more than this, to be trying to talk to a lawyer who is saying, I just object to all of it. I'm going to need you to be more specific. And they're still looking down. Look at me and tell me why you object. Still looking down at whatever she's looking at. Oh my God.
Your Honor, we don't think any of it should come in. We think it's all hearsay. We object to all of it.
You're going to have to be more specific. Do you believe that Ms. Richins' statements are hearsay?
Yes, because she is incorporating into her statements the hearsay statements that others are making about what happened in order to give her own explanation.
And
So, yes.
Okay. Any other objections?
No, sir.
Defendant's objection is overruled. Ms. Richins responding to questions posed to her by other hearsay speakers is categorically not hearsay. The court can instruct around the possibility
judge keeps
that
asking
the
for
jury
more
might
specifics.
consider the statements of speakers who are not Ms. Richins accepting their statements for the truth of the matter. Mr. Bloodworth, anything further there?
No, Your Honor.
great. We can move on.
Okay.
A few
That
of
name
you
was
have asked
277T.
what my dear friend Judge Abby thinks of this
All right,
judge
let's go to 270.
without oversharing. Attorney judge privileged next party conversations. Emily, it's not next party when it's your friend and you don't have case. Yes. It's just funny that we can call them our ex parties. Talk about judges. I imagine Judge Abby will start saying, can we invite the jury back? Because that parlance is really delightful. And while I love
Bring the jury.
it is we can invite the jury back in is just lovely. It's just lovely.
8T.
Yes. I like the way this judge handles things a lot, even when I don't agree with his rulings. He is very consistent. He is very mindful. He's aggressively flipping. He does a lot
Mr.
of
Bloodworth,
research.
take a look at page 11 with me, please.
This judge works
So-
his ass off.
Your Honor, maybe I can head some of this
Please.
off. So this, along with, I think it's 2-90, right? This all goes to recovery of the walk the dog letter, which is
Ooh.
entangled with a whole lot of
Ooh.
Kouri Richins is in jail. I have a proposal.
Why is recovery of the walk the dog letter going to be an issue that comes in before the
It
jury?
shouldn't.
I've already ruled on any
You
motions
have.
to suppress it.
I don't think it has to.
Unless the defense
so
wilds
sorry,
out,
which
I can. Oh my God, she's still like, what are we talking about? Unless the defense wilds out. If the defense wilds out, I can see why the prosecution might need to explain that the walk the dog letter was recovered in a way that we know it's Kouri Richins. I don't think Bloodworth can trust that the defense isn't gonna do something fucking weird, because they keep doing stuff that's just weird.
That comes in before the jury. I've already ruled on any motions to suppress it.
I don't think it has to.
Talk to me about the walk the dog letter.
I'm so sorry. Which number are we looking at right
Currently,
now?
we're looking at 78T and 90D.
Docket 214.
So at
every
the outset,
law
from the
nerd on
state's
internet
perspective,
calls
in
it the walk the
introducing the
dog
walk
letter.
the dog letter, how it was recovered, I don't know that matters. But I can envision a scenario where, for example, defense. The defendant has said that this 6-page walk the dog letter, it's been redacted down, but 6-page walk the dog letter was part of a 65-page fictional manuscript, and it was recovered from the middle or whatever of that manuscript, and
The lies. He's talking about the lies.
the context of it, the context of the 6 pages is within the volume of a book.
Excuse me. It is not just a book. This is spoilers for everyone that didn't follow through the pretrial motions, which I applaud because I appreciate your perspective if you're just coming into this case. However, mind me while I am petty for a moment about some spoilers. It is not just Mr. Bloodworth. It is not just a 65-page novel. It is the most in-depth, bestest novel that has ever been written. Ever, ever, ever. It is very thorough, in-depth, very detailed story. It is a novel. It's definitely not telling witnesses what to say in court. Definitely not. And it's definitely not accurate. I mean, some things have been changed. And it definitely starts on page 1. The letter is lettered page 1. And it definitely starts in the beginning. It is not taken from the middle of fucking anything, but I digress. It is a very in-depth 65-page novel. For those of you that are like, Emily, what the fuck is the walk the dog letter? The walk the dog letter was recovered out of Kouri Richins' jail cell after Kouri was on jail calls holding things up to the camera so that her mom could read them. And instead of the recorded calls, she thought if she didn't talk, that holding up the letter to the camera, her mom could just read it and then it wouldn't be recorded because the video of the jail calls wasn't recorded on the other person's end. The audio was. And so she was, it seems to me, trying to get around the recorded call to tell her mom things that weren't going to be recorded. And so law enforcement saw that. I imagine that the jail call system, when you're holding things up like that, automatically flags. And so I imagine, this is just my speculation, that the system itself automatically triggers that somebody's doing that and flags it for sheriffs to look at. And then they went and searched her jail cell, and then they found the walk the dog letter. And the walk the dog letter was inside an LSAT book all by itself, which is not what Kouri says. She said it was a novel. She said it was taken out of her attorney-client privileged envelope, blah, 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 blah. But they went and recovered it. They yoinked it from the jail cell. And then that all came in on the pretrial motions. The motion to dismiss was denied. The motion to suppress was denied. All of that has already been done. So now the walk the dog letter is going to come in partly redacted. It's listed in our Kouri Richins playlist if you want to go back to the very first day we ever saw the walk the dog letter, or if you want to wait till after trial, please do. It is your decision on that, but not all of it is coming in. it's been redacted. The part where Kouri Richins starts talking mad shit on her sister-in-laws, that part's not coming in because it serves no purpose other than to make Kouri Richins seem like a disgusting human. So that stuff's not coming in. Okay. Continuing on from the walk the dog letter, but that's what they're talking about now. So why redacted? Some of it is more prejudicial than probative at this point. I mean, if Kouri testifies, some of it might come back in because she might be able to be impeached with that or confronted about that. But some of it's not relevant. Some of it's more prejudicial than probative. So some of it will be redacted out. Kouri talking about sneaking in Crest White strips isn't coming in. Kouri talking shit about her sister-in-laws isn't coming in. The stuff about the case is coming in. So it's a balance. Continuing on.
That is untrue, and we could prove that by...
So the Bloodworth is arguing with the court, look, we need some of this information if the defense starts to distance from the walk the dog letter. Because it's not part of a larger novel in anything other than maybe what Kouri would like to believe. The first fucking page is numbered page 1. Why is it called the walk the dog letter?
Docket 214, but every law nerd on the internet calls it the walk the dog letter.
Okay, I try so hard not to side quest. We're just going to side quest for 30 seconds. I'm going to let Bloodworth finish. I'll pull up the walk the dog letter. It says walk the dog at the top of it. Walk the dog, but take vague notes. That's what it says at the top of the letter. I'll pull it up to show you after they're arguing about it, but yeah.
The middle or whatever of that manuscript, and the context of it, the context of the 6 pages is within the volume of a book. That is untrue.
It's clearly
we
not.
could prove that by proving how it was recovered.
Let's go in order of events, though. In terms of Jeff.
All right. So as they go in order of events, let's just bring up the walk the dog letter real quick. This is the walk the dog letter. This is why it is called the walk the dog letter. It clearly fucking says page 1. This is from the public docket. This came in back in September, 2023. Yeah, this was September 2023. Walk the dog letter. Walk the dog, but take vague notes so you remember. Asterisk. Sky is saying, even if the gummies have fentanyl in them, the prosecutor will say, I tried to put the fentanyl in the gummies so Eric would have them. This. It is a bad letter for her. It is Donna Adelson level bad. It is Donna level, you fool, bad.
Jeff O'Driscoll testifying about the walk the dog letter. Go ahead.
Here's my proposal.
Please.
I would like to show Jeff O'Driscoll a copy. Is this an accurate depiction of a 6-page letter to Lisa Darden written on either September the 12th or 13th, 2023, that investigators recovered on September the 14th, 2023, from a book that was among Kouri Richins' personal possessions?
Right. And then you leave it. It doesn't say that
Any
it was in
objection,
jail.
Rather than bringing in, so the idea would be he's not going to bring in 278T and
No, just we'll
Focus.
start there, and it will inform
Focus.
what we do with 78T and 90D.
So the way he just explained that answer, I don't know what I could object to.
Well, if you object to foundation, you're going to create a problem. So I just need to have
I need to know what we're doing.
What he's proposing is that question be non-objectionable based on foundation by stipulation of the parties.
Well, I don't plan to object to that question because I don't want to get into the fact that her cell was rousted.
Right.
So, I mean, I'm certainly not going to open that door.
Okay. So if it comes in that way, as I understand it, there's no need for the state to use 2-78T or 290D in its case in chief. Is that accurate?
Correct.
Okay. Ms. Nestor, anything further there?
No, sir.
Okay.
Woo. Okay, let's go back.
Okay, then can we go to
1.25?
2-93T?
For those of you just coming in, yes, a lot of this was done pre-trial. Some of it was not done during pre-trial because some of it is reliant on how the evidence has come in. So even though they've done a lot of things in the pre-trial, they are still just fine-tuning this. We saw this in the Depp Heard case. The juries did not come in on Friday, and they did a lot of this stuff on Fridays. We are now at the point where this is one of the next witnesses for the state, and it just has to be hammered out. The walk the dog letter is coming in, but only the first 3 pages of it. It's coming in with O'Driscoll. All right, continuing on. So they are just...
I think this is Ms. Richins talking about speaking with Ms. Bramwell and Heber.
Just
They're
very
narrowing
briefly, Your
it
Honor, I
down.
think they missed redacting the word jail call on the first page on this one. If we could just make sure they do that.
On page 2?
On page 1, the cover page, up at in the heading.
Oh, I don't think we're showing any of the cover pages of any of these, right?
I think they have the dates on them, so they may.
Yeah, Your Honor, we did miss that. We will fix that.
My apologies. Okay, very good. So jail call 1 will be redacted from the caption on page 1. Thank you.
The judges are just aggressively flipping at this point.
Help me out. What is the probative value of this one, Mr. Bloodworth? And is this only one that might come in rebuttal, or is this the case in chief?
No, Your Honor, the state withdraws this one. Now that we've resolved the Bramwell issue and she's testified, this is no longer necessary.
Look
Very
how
good.
easy that is.
2-93T is moot. All right, 2-94T. Part of this is regarding the vacation.
The reason the judge keeps saying T is because T stands for transcript. So they are going through the transcripts to redact it out, and they will then redact out the correlating lines in the call, which is why there are multiple people from the prosecution team doing this. Sally asked if they'll have witnesses today. They were supposed to be started with witnesses by now, but they are running a bit behind doing this today. They're supposed to
Vacation
have
booking
witnesses today.
statements.
I anticipate
Part of
they'll
this
have
is Kouri
witnesses today.
Richins making statements regarding the vacation booking statements.
And we will let you know.
And part of this is regarding the thing in Heber.
We'll let
Candidly,
you know
the statements or the back and forth regarding the quote-unquote thing in Heber is pretty confusing.
in the app.
The first part, I think, is more clearly probative.
This one also, Your Honor, they missed jail call on the cover page. If we could just redact that.
Scott, page 1 of 2-94T in the caption.
Yeah, the jury is
Please
still out.
redact jail call 2 from the caption.
There you go.
So we will keep you posted in the Law Nerd app if the legal wranglings are like, what are we doing? It's fair. And for any of you guys watching ahead in real time, thank you for no spoilers. We are watching this in EDB time. And so I appreciate that because we are watching it in EDB time and I'm watching it with y'all.
Your Honor, at this point, because of the way the evidence came in, the
This is
state will
great.
withdraw this one as well.
This is a great question.
I can envision some corner cases where we might want to revisit it, but for now, let's just set it aside.
Very good.
Probative value, Ruby Roo Crochet, simply means that it is instructive to the jury. It is probative of some fact. It is helpful to some fact versus being more prejudicial. Yes, things that come in are going to be prejudicial. Otherwise, they're probably not relevant. If you're trying someone for murder, it needs to go towards the fact that Kouri murdered someone. That's prejudicial. It doesn't look good for Kouri. But it can't just be prejudicial. Kouri being disgusting to her sister-in-laws doesn't help the jury decide a fact. It doesn't help the jury decide whether she gave Eric Richins fentanyl or not. It doesn't help with any of that. It's just her being an asshole to her sister-in-laws. And maybe she feels completely valid in being an asshole to her sister-in-laws. But it doesn't help establish a fact. It just makes her look like a giant asshole. So that doesn't come in. More prejudicial than probative. Probative is, Kouri saying, I never even gave him a drink. I never even gave him a sandwich. I didn't even make the sandwich. That helps the jury decide, is Kouri lying because she knows she gave him a sandwich and it made him sick and she's trying to distance it? That gives more information. So hopefully that helps. Some people think the financial information was prejudicial. It was incredibly prejudicial, but it was also more probative. It helped the jury decide a fact more than it was just prejudicial. But yeah, if it's not prejudicial, it's probably not relevant. It's the balancing act. All right. They are all still flipping as we go through. We're still in jail calls and jail video.
Right, Mr. Bloodworth?
We're still going through jail calls and jail video. We're at 1.25 speed. Still.
Oh, no, so that went the same way as 270AT and 290T.
Got it. Okay. Ms. Nestor, I think that resolves the state's docket 1165. Anything further on that?
No, sir.
Okay.
Mr. Bloodworth?
Moving on.
No, sir, nothing on that. We recently identified 3 additional jail calls that we've redacted. We'll send those to the defense today.
All right. 3 new jail calls.
I don't anticipate introducing them today, but
Okay.
so we may have additional similar discussions.
Understood. And then, let's see. May I ask about the state's
Also,
motion to admit redacted?
2 things on that. The state identified additional jail calls they may use. This could be 2 things. One, it could be something that now has become more relevant based on evidence that's come in the trial. So that could be part of it. And the defense has all the jail calls the state has. It's just hey, we're going to use this one because there are so many of them. The state has been identifying which they're going to use. The state has not given the defense, and I'm making up this number, but the state has not given the defense 1,000 jail calls and been like, good luck figuring out which one we're going to use. The state is identifying and narrowing down which ones they're going to use for the defense. However, it could also be that the defendant's getting back to custody at night and picking up the telephone and having a little bit of a combo, and those are still getting downloaded and sent to the defense. So it could be brand new jail calls. It could be one of those 2 circumstances. So it could be one of those 2 things.
Exhibits 8-57R through 8-63R.
So now we are moving on a bit.
That is the state's designation of prior consistent statements by Carmen Lauber. May we talk mechanics for just
All right, I want to hear about this.
how are
started
these
to
coming
come
in
up.
mechanically?
The Carmen Lauber stuff started to come up the other day when they were talking about her interviews the same way they were talking about Crozier's interviews.
So, Your Honor, in questioning
So I slowed this back down to talk
Jeff
while they talk about
today,
Carmen Lauber.
I will ask him about conduct of the interview of Carmen Lauber. Ask him about the defense's question. He was present when the defense questioned Carmen Lauber about certain statements. In context, do those, are those statements, fair? No. And then move to admit the various 57 through 60, whatever.
So I appreciate that the state has evidence through Jeff O'Driscoll and perhaps others that the arc of the interview, particularly the conduct by law enforcement officers or investigators and Ms. Lauber's responses thereto, are not the same as suggested by defense's cross of Ms. Lauber.
Okay.
But you can elicit that evidence through Detective O'Driscoll's testimony. And to the extent you need to show that Carmen Lauber testified consistently with her direct versus
The insinuation.
the suggestions of what she said or what she said on cross, you can certainly do that. My question is, though, it seems like a lot of this is being shown the arc of the investigator's conduct rather than just Carmen Lauber's prior consistent statements. Now, I understand context matters, but do we really need all of it, is my question.
It's a fair question.
Your Honor, the state tried to narrowly tailor.
The chat, let me know what you think if you watched the Carmen Lauber testimony. Did the defense try to insinuate that law enforcement just told Carmen Lauber what to say and that Carmen Lauber was a convenient mouthpiece to just get up there and say whatever? Not that she was testifying truthfully, but that she was testifying to whatever law enforcement wanted her to say. Because I think the defense put that insinuation out there that Carmen was just, parroting whatever law enforcement said. And she's like, I'll do whatever, I'll say whatever. Just tell me the lines. Line. Not that she was telling the truth because she got a deal, that she was telling what they wanted her to. And so that is part of where showing law enforcement's interviews with her might become relevant, showing that that's not what was happening.
The amount of information, I think.
And to be clear, I recognize that we went from 900 pages down to 100-ish.
I mean,
I understand that.
That's a lot.
I think those 100 or so pages, narrowly tailored, are kind of the minimal amount to show the motive, Carmen Lauber's motive, that it was more, certainly there was a self-serving piece, but there was a lot more than a self-serving piece, and that she was not motivated by,
I gotta say, I love the up closes.
O'Driscoll and
the up closes. I love the up close zooms on Bloodworth because we get to also see Scott's mustache.
Maynard bullying her.
Right.
I think the full expanded 900 pages show that the best. I think the 100 or so we called to show it enough.
Do you have these as one kind of video clip that plays from interview to interview, or will you provide some signposts for the jury as you introduce them?
Your Honor, we don't intend to publish them. We intend to make a few points from them through Detective O'Driscoll's testimony, provide them to the jury, and in argument argue something like, you heard the defense cross-examine Carmen Lauber. You heard Detective O'Driscoll's testimony regarding those interviews. You have them before you if you want to, or you have these excerpts before you if you want to dig through them and determine for yourself what the evidence proves.
Okay. I appreciate the efficiency of this. I have a genuine question as to whether I can send these transcripts back into the jury room when I'm not sending other transcripts of other testimony back into the jury room.
But aren't the transcripts
Some-
evidence?
Your Honor, it's not testimony. It's evidence. It's an interview.
I mean, we'd have to go through the Crawford analysis to figure out if Ms. Lauber's statements were testimonial. Now, there's not a Crawford problem because she was on the stand.
Correct.
Right.
But whether these qualify as testimony with respect
Then just play
to
the interviews.
the concern that providing transcripts of certain testimony would give that certain testimony undue weight when transcripts of other testimony are not provided. That
Can't
I
you
have a
just play the
genuine
interviews
question
and
about.
send the
So
interviews
I'm not
back then?
suggesting that you can't publish.
Sure.
I'm asking whether
Wait,
you
aren't the transcripts of everything going back, or is it just the video?
have to publish but not admit.
Huh.
But she was in custody. She was being questioned by law enforcement officers. I think there's at least a reasonable question as to whether this would qualify as testimonial, quote unquote.
I think two things, Your Honor. In some measure, that's why the state moved to admit the entire shebang. But I appreciate the
You
need
just said the
for
entire
efficiency.
shebang.
The
All 900 pages.
second thought I have is, to the extent that the defense wants to
Scott's like in there editing while they're
further
making these arguments.
cross-examine Carmen Lauber on these, or Detective O'Driscoll or Detective Maynard, they're here. We can all recall them easily.
I agree. Yeah, no, I agree with all of that. It really comes back to the issue of whether these transcripts go into the jury room.
Just play the video.
You're right. You have the right to publish them to the extent you want to. I am not persuaded sitting here right now that they go into the jury room. So we don't have to necessarily reach agreement on that piece right now, but how do you want to proceed with Detective O'Driscoll on recognizing that they may not go into the jury room?
Well, then you need to play the videos.
Your Honor, that would
You need to play the videos on. And
alter
the transcripts need
the
to be
state's directive
on the
of
videos.
Detective O'Driscoll, because we would end up publishing 100 pages of transcripts.
You have them as video or audio, though, too, right?
Well, right now, we only have the transcript.
Oh.
We were waiting. Video editing is long and expensive.
I see.
And so we were waiting to nail down the transcript to then conform the video.
Is audio easier? Do you have audio files?
What did
Ms. Shermack is saying no.
it's the video file is the audio file.
I
The
see.
same.
It's one.
I see.
So there's no distinction in terms of editing time between a video and an audio file.
All right, pause there for a moment. Maybe I may be taking on more.
So this is that makes sense. They haven't edited down the video yet. They have 900 pages of transcript, and they're not going to start cutting the video until they know what the court is allowing in, and then they have to cut the video. There are 900 pages of transcripts because it's 10 different interviews. I can understand the state being like, well, we could just play all of it. I mean, we'll be here for a day, but we could just play all 10 interviews then. But not all of it's appropriate. And the state is trying to eliminate going line by line for 900 pages of transcripts. And they've narrowed it down from 900 pages to 100 pages. But then they have to go out and edit the video, and they haven't done that yet. But the judge is worried, and I understand the judge's concern. The judge is worried if you just send the transcript back with the jury, somehow it's different than everything else, and the different thing can stand out in your mind more, where the other videos have the video and then the transcript scrolling along the bottom. I understand the issue from both perspectives.
More than I need
That's
to.
a
Ms. Lewis, what's
pickle.
the defendant's view of this?
Or pickle-flavored
Your Honor,
popcorn.
we object to these coming in this way. I think that
When you say this way, what do you mean?
Oh, now Lewis
by
is objecting.
publishing any of these transcripts, I think you're correct that the appropriate way to do this would be through direct examination of Detective O'Driscoll. They can certainly ask him questions to try and rehabilitate what Carmen Lauber said.
Can ask him questions
But the
about
video's
what
better.
he said. They can't ask him questions about what she said. That'd
Right.
be hearsay.
I understand, but the problem
But-
that as they see it, if I understand it, is they're trying to put forth that she wasn't influenced by law enforcement. So they can ask questions of Detective O'Driscoll about that. But putting these in, I do believe is a Crawford problem.
Well, hold on.
He already said there isn't. That's not the issue.
I need you to compartmentalize the objections here. These are being offered as prior consistent statements of Carmen Lauber to rebut a charge of either recent fabrication or undue influence.
Correct.
I understand.
So, any objection under
Agreed.
that rule?
Yes, that should have come in under Carmen. During cross-examination, it's fully within our right to pick out portions of this interview to
But you
show.
can recall her, right?
I don't think that's our job to recall
No,
the state's
they can
star
recall
witness.
her.
They had her on the stand.
I just asked you a yes or no question. Would you start there for me?
She's like, no.
Could we recall her? Yes, that is something that could be.
Then it's not a
possibly
Crawford problem.
done. I don't imagine what world the defense would do that. But
And correct me if I'm wrong, you had the transcripts when you cross-examined her, right?
yes, but so did they. And the
We've
appropriate
covered
way
this.
to do it
They did this
would have been to try and
yesterday.
rehabilitate her on redirect, which would have then given me a chance to go into other statements.
They sought
During
to,
cross.
and I limited their ability to put in the whole 900 pages.
That's not how you rehabilitate. You rehabilitate by asking questions. It's not by putting in an entire transcript.
Well, you
And-
can do it, for example, by admitting prior consistent statements. And so I just need you to stay focused on that rule for a moment. I know I'm interrupting you.
Yeah.
Well, because she's not on the.
I don't understand how you think they were
Where
supposed to.
somebody pulled the switcher and we're on different fucking train tracks at this point. Is this a Crawford problem? No? Great. Can we move on? Chat, Crawford, confrontation. Is this a problem that they can't cross-examine this witness about it? Is this a confrontation issue? Do they not get to question Carmen Lauber about it? And again, we talked about this either yesterday or at the end of the week on Thursday, where they said to the defense, did you have all these interviews before she testified? Yes. Okay. This has already been addressed. This has already been
to
addressed.
admit prior consistent statements.
Through testimony.
That's not a prior consistent statement. The whole reason we have the prior consistent statement rule is because the testimony goes in a different direction. Or there's a charge of recent fabrication or undue influence. And then you have the prior statement come in
Why
as
are we doing this
substantive
again?
evidence.
Only while she's on the stand. They didn't even attempt to question her about whether or not to pull out these portions to show, oh, look at, you weren't unduly influenced. Look at, you said this, is that correct? Is that correct? That's how you would normally see this done. Then I could have cross-examined her. And I also want to point out
This question's
that
been issued.
they
This
have
issue's
taken
been
very
dealt
small
with.
portions of this that leave out the portions of the interview where she is being influenced by statements of law enforcement. This makes it look like, I mean, they've cherry-picked what they want. And for example, I want to pull out the May 10th interview. I don't even understand why this would be coming in. All they've pulled out is a conversation between Ms. Whistler and Ms. Lauber that Ms. Lauber is supposed to testify before the grand jury. That's going to open up a whole door of speculation and what happened. I don't see how that has anything to do
We're
with
spiraling.
what we've been talking
Counsel,
about.
counsel.
And as I go through the transcripts, it's very much just what
Ma'am.
the state wants the jury to hear. I mean, if we're going to do this, which I think is completely inappropriate,
We've
this
spiraled.
is a Crawford problem. This should have been brought in through testimony when Carmen Lauber was on the stand, so she could have been cross-examined. They can bring in what they want through Detective O'Driscoll, because we still have an opportunity to cross-examine him. But to just send back portions of a transcript that we've not been allowed to cross-examine on, that point out to the jury just what they want the jury to hear, is inappropriate.
And I apologize, you're jumping around a little bit. So
Like
put
House of
aside
Pain.
sending transcripts back. I have concerns about that. Do you have any law for the proposition that prior consistent statements can only come in through the witness that makes the statement?
Well, I would point to a case. Let me pull it up again. I had it. Just give me a moment.
Vibes is not valid law.
I can't find it.
The Crawford problem
One
she's
moment,
talking
please.
about is from Crawford v. Washington regarding the right to confrontation, Sixth Amendment right to confrontation. She keeps saying this is a Crawford problem. Saying Crawford 3 times is not like Beetlejuice. It doesn't just make
It's
it so.
366 P. 3rd, 867, State of Utah in the interest of JC.
I'm sorry, would you give me the site one more time?
366 P. 3rd, 867. And I direct the court to footnote 8.
Okay. All right, so I understand your objection there. Tell me why you think it's a Crawford problem. You had the opportunity to cross-examine Ms. Lauber. You did cross-examine Ms. Lauber. You used part of these interviews to cross-examine her, to challenge her on whether she just asked.
I'm going to lose my fucking mind. We talked about this like at least 2 days ago. You said like 2 days ago this wasn't a Crawford problem. It might have been more than 2 days ago that this was. We already did this. Why are we doing it again? It's like when your kids are like, okay, I know what you said. However, might you change your mind? Because I would like you to. AR in the chat said P. Sherman Wallaby Way. Yes. Every time they cite to P whatever, I think P. Sherman Wallaby Way as well. For everyone just coming in, look, the jury has not come in yet this morning. The jury is still out. I don't know how far we are in real time, but the jury was coming in an hour late so they could do this. I am time blind. I have no idea how long we've been at this. It feels like 100 years. And they are still going through what is going to come in with the investigating officer O'Driscoll. We have gone through jail calls, Kouri Richins' big interview, the walk the dog letter, and now we are talking about Carmen Lauber. And this happened a couple days ago, and now we are circling back. Wait, we found it. We found it. We found it. Miss Lewis has, in fact, come back to that. It's not the way we thought she would, but she has, in fact, come back to this again. And the judge is like, why?
The law enforcement officers, investigators just write her statement for her. I don't understand what a lack of confrontation Ms. Richins has had here.
Because Because what is happening here is now they are basically crafting testimony on her behalf. They should have asked her these questions. I haven't had an opportunity to cross-examine her on what they now want to bring in.
Yeah,
they should have brought it in through direct, and instead
they had the opportunity. You had the transcripts. You wanted them to not bring it in, but you had the transcripts. You want to leave the insinuation that she was just a mouthpiece for law enforcement. They're allowed to ask about that.
Which I get was difficult with her. You know, she said she didn't remember anything. Instead of doing the hard work to try and ask her questions, they just want to put it all in. And they want to cherry pick what they wanted her to say, which clearly would have been very difficult to get her to say. So the easy way is here. We're just going to hand you the transcripts that show you what we wanted Carmen Lauber to tell you, but instead, here, just read it.
I don't think
without putting in the whole story or giving me a chance to.
They wanted to put in the whole 900 pages. That's where we started. We started with them wanting to put in the whole 900 pages and then narrowing.
Go back and cross-examine her. And I think requesting us to recall her is burden shifting. That is not what our job is. That's not what we needed to do. They needed to take care of their witness when their witness was on the stand.
They can do it this way too, though. They're allowed to. They're allowed to bring in these interviews.
You objected to the addition of any part of the transcript at the time they offered it.
Yes, she
For
did.
the same reason. They offered it after she was off the stand.
Had they offered it the 900 pages when she was on the stand, you would have said okay.
No, she wouldn't.
No, I would have said you need to cross-examine her, redirect her and rehabilitate her testimony.
And so how do you see the rule regarding prior consistent statements working?
They need to get it through her. They could have put on prior consistent statements through her.
I really don't understand. You're saying that prior consistent statements never come in. You only can ask questions. Please help me understand.
I don't understand. I'm sorry, Your Honor. I really am not following what you're trying to say. I have never seen this done any other way than through a witness. That's why we have witnesses. If not, why have any witnesses? Let's just hand the jury all the evidence. Let's hand them all the transcripts of
Well, no, be fair to how the rule works. Somebody testifies. On cross-examination, defendant makes a charge of recent fabrication, and then the proffering party has an opportunity to offer prior consistent statements to rebut the charge of recent fabrication. Well, I hear you saying, no, they cannot offer the prior statements. They can only...
They can offer it, and they don't have to offer it with the witness. Just because you've never seen it done, the thing is, you are trying to play chess with Bloodworth. Just because other prosecutors might not be as good does not mean it cannot be done. Oh boy.
Charge of recent fabrication, and then the proffering party has an opportunity to offer prior consistent statements to rebut the charge of recent fabrication. I hear you saying, no, they cannot offer the prior statements. They can only ask more questions.
They can offer them through the witness. They can say, is this your statement? And what if she says, I don't remember that? Okay, then they can refresh. What if she says, I don't remember that? Well, then it doesn't come in.
Okay, I think that's where maybe you and I differ on the way the rule works. Do you have any citation for a law that says, unless the witness remembers, these don't come in?
Well, off the top of my head, I'd have to spend some time, but I would look at Rule 613 of the Utah Rules of Evidence that talks about,
Are we picking up Rule 613?
well, this talks about prior inconsistent statements, but applicants
but
given the
prior
opportunity to
consistent
explain or
statements.
deny the statement, and adverse parties given the opportunity to examine the witness about it. We don't know what she would have said. We don't know if she would have
You
said...
do. You asked her.
I mean, she may have very well said, no, I didn't feel influenced at all. You know, that's fine. They could have asked her that question. Then I could have
They did.
cross-examined her or recrossed her to say, well, what about this? What about this? What about this? Now I'm denied any opportunity to do that.
You argued
by
about
just
this
putting
3 days
in
ago.
statements. And I mean, I really don't know what else to say. I do think as I look through the transcripts, they have only picked things that they want in that we don't know that Carmen Lauber would have agreed to. But had they wanted to put them in through her, at least then I could have questioned her.
You could have questioned her. You had the transcripts.
I mean, I could have questioned her. I could have said, you know, so this didn't make you feel pressured, so that didn't make you feel pressured. So they said this, so that made it, you know, so you felt you were telling, I don't know. I mean, you see where I'm getting. And
No,
I don't
he
have any
doesn't.
opportunity to do that in this way. They can ask Detective O'Driscoll questions. We can cross-examine Detective O'Driscoll, and the jury can make a determination of that. But
They're
by
allowed-
cherry-picking statements that they wanted Carmen Lauber to testify to, but didn't ask her, I think that's error.
It's not the chair.
And this gets to the, well, Your Honor, it's error. It's error, Your Honor. This gets to the, you're going to make a ruling that's going to overturn this case. This is, we disagree. It's error. And they drop that in so often, it is just lost all meaning for me at this point. But the defense had this conversation with the court however many days ago. It wasn't yesterday. It was at the end of last week sometime when this issue initially came up. And they talked about it when Crozier's prior consistent statements were played and prior inconsistent statements. They talked about it then. We have gone around and around on this multiple times.
Cherry picking, it's the root, right?
It is.
I mean,
I'm going to let the court finish their full statement.
They wanted Carmen Lauber to testify to, but didn't ask her. I think that's error.
That's disingenuous.
it's not the cherry picking, it's the root, right?
It is.
I mean, you cherry picked statements too. Everybody cherry picks
Right,
statements.
and they could have done it on redirect, and they chose not to.
So again, it's the root, not the cherry picking, right? If she were on the stand, the cherry picking would not be a problem.
They could have, because then I could have gone back and pulled out other statements.
I think we're agreed. Okay. All right. All right. I take your argument seriously. Mr. Bloodworth, I'm going to have to take a look at this real quick. I understand this to be a threshold issue with respect to Detective O'Driscoll. Is that right?
Yes, Your Honor.
Okay. Anything further at this moment?
I think if he wants it in, we just say send it over.
The defense is at counsel table chatting about send it all back.
Your Honor, I'm pausing.
We saw the pause. The jury is still out this morning.
Can we have 5 minutes?
Of course. Just so I'm clear, we'll take 5 minutes for you to confer with your team, and then you'll tell me whether this is a threshold issue that I need to decide before Detective O'Driscoll takes this.
Correct, Your Honor. It is now. That may change.
Okay, understood. We'll take a 5-minute recess. Thank you.
What the court means by it's a threshold issue is we can't have O'Driscoll on the stand until this issue is resolved. Okay, so they're taking 5 minutes. We're gonna zoom. That seems longer than 5 minutes, just based on how far I have to scroll to get to it. If you are just joining me, good morning. Remember, spoilers will be heated, and then you will not be able to chat. So, spoilers are disallowed. We are watching Behind Real Time and pausing and talking about the legal arguments. All we have done this morning so far are legal arguments with regard to what evidence is coming in. They talked about jail calls. They talked about the walk the dog letter. They talked about text messages from jail. They talked about defendant's interview with O'Driscoll. We are now on the issue of Carmen Lauber and talking about Carmen Lauber's interviews with law enforcement. Remember, there are 10-ish interviews with Carmen Lauber, 900 pages of transcripts. And they are trying to figure out if this is an issue that they can't begin O'Driscoll as a witness until this is resolved or not.
Please.
That's what they are trying to decide now. So, oh my goodness.
Mr. Bloodworth, before
So they took a
you
break.
weigh in,
We are
I need
back.
to fix a misstatement that I made while discussing Detective O'Driscoll's potential testimony. I made a comment in passing that he cannot relate Ms. Lauber's statements because it would be hearsay. That is overly broad. To the extent that the statement by Ms. Lauber that Jeff O'Driscoll would seek to relate while testifying qualifies as a prior inconsistent statement under 801D1A or
Okay.
a prior consistent statement under 801D1B, it is categorically not hearsay and he can relate it. By the same token, it can come in through him. Ms. Lewis, I took a hard look at the case you cited me to, 366 P3rd 867, footnote 8. There, the Utah Supreme Court related the competing positions by the state and the respondent. Those competing positions are substantively identical to the competing positions of the state and defendant here regarding how statements under 801D1 are to come in, and the Utah Supreme Court expressly declined to reach the issue.
Oh,
they
boy.
did not rule that they must come in
punted.
through the declarant. So, as I sit here today,
Ma'am, you cited a case to say the thing you wanted it to say, and the court specifically said, nope. Because that's what courts do, right? They decide the most narrow issue that they have to. They do not decide things more broadly. And on specifically that issue, they punted. And they did not say that the statement had to come in through the declarant. Oh my God. Okay.
there is no authority for the proposition that prior inconsistent or prior consistent statements can only come in through the declarant witness as long as the declarant witness testified and was subject to cross-examination.
Right.
Indeed, it is defendant's cross-examination of Ms. Lauber
That caused this
creates the foundation for admission of prior inconsistent statements based upon Ms. Lauber having not remembered or having forgotten, though that's not what the state is seeking to do here, and prior consistent statements based upon an express or implied charge that Ms. Lauber was acting from a recent improper influence or motive, to wit, pressure applied by, among others, Detective O'Driscoll, the U.S. Attorney's Office, agencies like that.
That's exactly what
There is
they
not
charged.
a Crawford problem here. I also have another thought regarding the transcripts going back.
I would love
if
to
you
hear
want
your thoughts,
discuss
Your
that.
Honor.
So maybe we can get the court's thought, and then I can incorporate that into the state's position.
I would love to
Sure.
hear the court's thoughts.
Under Wyatt v. State, 2021 UT 32, under paragraph 21, the Utah Supreme Court abrogated the common law rule that prevented testimonial transcripts from going back into the jury room based upon a concern of undue influence on the basis that Rule 17K of their Utah Rules of Criminal Procedure does not allow for any categorical exceptions to exhibits going back with the jury, because the jury may take with them, quote, all exhibits, end quote, except those, quote, that should not, in the opinion of the court, be in the possession of the jury.
Like a
end
weapon.
Quote. Now, typically that's gun.
Yeah, guns, knives. Your Honor, you were really busy doing case research over the break. Oh, boy.
Quote, except those, quote, that should not, in the opinion of the court, be in the possession of the jury, end quote. Now, typically that's guns, knives, poison, explosives. I still have some concern that given the volume of testimony that the jury hears, the only transcripts they would have in the jury room being this 100-ish pages of Carmen Lauber would attract
It would be
some
weird.
unwanted attention on appellate review.
Remember, we have talked about this in other trials. Don't be weird. Don't do something weird. You don't want to do something weird. When there is one thing that is not like the other, it tends to stick out more than the others. So if everything else is going back in the form of a video or audio, just sending these back as paper is weird. It's the one thing that does not fit. I understand the court's position on that, which means the prosecution is going to have to then edit the video, I guess, because don't be weird. Okay.
But under Wyatt v. State, 2021 UT 32, there's no categorical exclusion of them. Take it from there, Mr. Bloodworth.
So, Your Honor, it's the state's position. I know I'm recapping a little bit of what you just said. It's the state's position that the court can admit the transcripts through Detective O'Driscoll. We don't need the declarant, Carmen Lauber. It's the state's position that there is no Crawford issue, in part because of the 801D1 requirement for opportunity to cross has been satisfied in this instance.
Right.
It's the state's position that the defense, to the extent they want to recall Carmen Lauber,
they have the opportunity to do
burden
so.
shifting. It's just a defense strategic choice.
Wander back to the mic, Bloodworth. The background noise is killing us.
It's the state's position that the transcripts can go back to the jury. Now, having said all of that, prophylactically and out of an abundance of caution, the state is trying to, through her attorney, recall Carmen Lauber, put the transcripts in through her, and then publish 100 pages of transcript. As much as the state thinks that is horribly, horribly inefficient and unnecessary. We've reached out to her attorney. I do not yet have an answer.
Okay.
This is a threshold issue for, I don't know, the midpoint of Jeff O'Driscoll's examination. So I propose our next witness is Chris Kotrodimos to clean up some stuff from yesterday.
Okay.
I propose we next call him. We then begin the state's direct examination of Detective O'Driscoll. That'll probably take us to
The rest
lunch.
of the day. Oh, not the rest of the day.
May have a better answer at lunch as to how the state will proceed.
Okay. Let me just ask some mechanics questions. Why can't the state just ask Jeff O'Driscoll a bunch of questions about whether certain exchanges with Ms. Lauber occurred? And, to the extent he doesn't remember or can't remember specifically, use the transcripts to refresh his recollection and even show the jury publish them at that time, but use him as the root. And if you want to call him as Lauber, you're entitled to do so.
Your Honor, that may be the route anyway, and it may just, from an efficiency standpoint, going through the questioning to ultimately get to refreshing and publishing, it seems to me that that's waste time. It will be more efficient to just publish the 100 pages.
Okay.
Because that's where we're going to land anyway.
Can we edit the video and just play the video?
Ms. Lewis, please proceed.
I just want to make a record.
Go ahead.
Sure. You disagree?
We stand by our objection that allowing prior consistent statements to come in without a sponsoring witness is a violation of both the Sixth Amendment right, of our client's Sixth Amendment right, and
You've made this record 6 times. The court has said no like 6 times. There is a sponsoring witness. It's just not the way you want to do it. This is not a Burger King.
Crawford versus Washington.
It does not.
It also violates her right to due process under the Utah State Constitution and the federal Constitution. She is not receiving a fair trial. And the remedy that we should recall the state star witness absolutely is burden shifting, and we stand by our objection. If those 100 pages are going to be published, we want all of it published. We want all 1,000 pages.
All right. And how do you want?
The judge is just blinking. The judge is just blinking his eyes. He's like, okay, you want all 900 pages then? We heard them talking about that at counsel table a little bit. I'm going to back that up if you're listening in the background so you can see the judge go, so now you would like all 900 pages published. Okay. There's going to be stuff in there about your client being in custody. I'm sure you don't want every line of every 900 page. Are we just delaying? What are we doing?
100 pages are going to be published. We want all of it published. We want all 1,000 pages.
All right. And how do you want that to occur? Do you want to just play the interviews with Ms. Lauber?
Yeah. Yes. Sure.
Sure, we could do that. We could just play them all. They're 7.5 hours, but that's how we want to do it.
No, that's not
And
how
tell
anybody wants to
me-
do it. You're just trying to hold the court hostage. You're bluffing with the court. You're just trying to hold the court hostage. It's 7.5 hours, Your Honor. You want to sit through 7.5 hours? Right.
Sure, we could do that. We could just play them all. They're 7.5 hours, but that's how we want to do it.
And tell me why you want to do that.
Because there are numerous other
So that the jury will get so bored that they'll zone out and they won't listen to any of it, Your Honor. We want to bore them to death so it will all get lost in the sauce.
portions of the interviews where she is being influenced by law enforcement and shows that she's willing to just go along with whatever they say, just as she stated. But I think to pick out, particularly, like I said, the May 10th interview, there are a lot of things she says in that interview that are inconsistent with all of her other statements, but the state just wants to publish that she was going to testify before the grand jury, which I don't even understand that. I mean, all that does is cause the jury to speculate and confuse issues. And that's just one example out of what they've pulled out of the transcripts.
We're back where we started, Mr. Bloodworth. This is the position the state originally took. Does this change anything?
Your Honor, it's largely the state's initial position. The initial position of the state was then not to publish them, right? It was just to send them back so that the jury could, if they wanted to. I'm happy to send the whole things back.
Ms. Lewis, speak to that.
We're not asking, that's only if, we are not suggesting that that should happen, only if we're overruled. We'd rather it
Which
all go
specific
back.
part? You got to be a little bit specific.
We're not suggesting, it's not our position that any of this should go back. We're only saying if the court's going to allow some of it to go back, then under Rule 106, we need it all to go back.
forgive me, you've pivoted again. It's stay away from going back. Let's just stay on publishing.
Can we just go forward?
So I understand defendant's position to be if any of it's published, all of it has to be published.
Yes.
Correct.
Okay. In response to that, the state, as I understand it, is suggesting I'm inferring in the interest of efficiency, rather than publishing all of it, just make all of it available to the jury through the recordings and then allow counsel to make whatever arguments they want to make about you should go back and listen to this part because you'll see this is what was happening. Speak to that for a minute. You could do that by stipulation.
I'm not going to stipulate to that. No.
So
then what do you want?
Stands.
Let me start again. Imagine that your objection to publishing anything is overruled, and that's the world you're living in. How do you want to proceed from there?
I mean, I think I said that. Then it should all go back. Or
Again, you keep skipping to going back. I want you to talk about publishing for a minute.
so my hesitation is just efficiency. Like I said, it's over 7 hours worth of video. But if that's how the court wants to do it, then yes.
No.
That's
what I'm asking
not what
you.
he's asking.
So imagine, here, I'll just make a ruling.
Yeah, that's better.
I have considered carefully the authorities cited by
That's better.
defendant and the
He's
state.
trying to
I've
work
looked
with
at
you,
the text
and you're just like, no. So he's like, fuck it, no.
Rule 801, ruling is a matter of law that, one, there's no Crawford problem here because Ms. Lauber testified in open court
They've done
under
this
oath,
3 times.
was cross-examined in open court under oath. It is the cross-examination of her regarding the conduct and circumstances in her prior interviews with law enforcement and other agencies that creates the circumstances providing the foundation for admission of her prior consistent statements under 801D1B. So the defendants further, the court is not persuaded that the only witness through whom a prior consistent statement may be admitted is the declarant witness that made the statement.
Correct.
The court has not seen any authority for that proposition. So to the extent the defendant objects to any of Ms. Lauber's prior consistent statements coming in any way, that objection is overruled. So, Ms. Lewis, take it from there. Some of
So
her
now we can't go
prior
back. I've
consistent
ruled.
statements as
Now what?
designated by the state are admissible under Rule 801D1B. It's how we're going to provide that information to the jury that I need some input on.
Well, I
we
guess-
could just publish. We could admit and send back into the jury room. Speak to those two options.
Well, my understanding was that under the case you just cited, Wyatt, that you were going to allow the portions to go back to the jury room. Did I misunderstand that?
Well,
He kept asking. Holy shit. No, he kept asking about it, and you kept circling back to other shit. He kept trying to get you to answer that exact question, and you kept going back to other stuff. That's what he wanted you to answer 40 minutes ago.
The willies, quite frankly, and that's why Mr.
The court doesn't want that option. That's what he kept saying. It's weird, and he doesn't want to do anything weird. Rule number 1, don't do anything weird. Sending back one transcript when nothing else is a transcript is weird. It sticks out too much. It is an anomaly. It is an anomaly. It is weird. He doesn't want to do it. It's weird. And so that's why he's saying, what do you want to do? Which is why we're backing up to let him say, it's weird. I don't want to do it. He doesn't like it. The judge is not comfy with that option.
Input on.
Well,
we could just publish. We could admit and send back into the jury room. speak to those two options.
Well, my understanding was that under the case you just cited, Wyatt, that you were going to allow the portions to go back to the jury room. Did I misunderstand that?
Well,
Yes.
I think there's a basis to do so. It gives me the willies, quite frankly, and that's
Yeah, he
why
doesn't wanna
Mr.
do it.
Bloodworth, out of an abundance of caution, is saying prophylactically to prevent any appellate issue there.
The court doesn't
we would
like it.
just publish. But if the defendant believes,
Which I think is unfriendly
Judge, if
to
you
the
do-
state. I think that's more friendly to the defense. I think that is an unfriendly to the state ruling. The judge is like, it makes me uncomfy. I don't want to do it that way. Which I think is more friendly to the defense to do it that way. But it gives the judge the willies. He doesn't like it.
do this, the least prejudicial way for us to do it is to send the recordings, all 7.5
Yeah.
hours, into the jury room and allow counsel to make arguments about what they show and what the jury should take from them. You could do that by stipulation.
No, I don't want to do that. I think that even though it's not efficient, the appropriate way is if any of the
And the
interviews
defense
are
is
going to be
like,
published,
mount
they
up and
all
ride.
need to be published.
Publish them
Okay,
all in court.
only published.
Correct.
All right.
Well, if they
I
get
appreciate
published, then
your
they go
position.
back.
Mr. Bloodworth, take it from there.
Published means played in court.
Your Honor, the state
Has a right to try its case the way it wants
moves
to.
to just publish the narrowly tailored versions that we proposed as whatever it is, 8-57 through 63R.
Right.
I think beyond so, I don't think there's a 106 concern beyond that.
I don't know. We're going to find out, but okay.
Yeah, and
And the state's like, fine, we'll
As-
publish what we've identified.
compromise. The state is fine with sending full videos back, or some mix of publish the narrow pages and send a full video back.
They don't have to publish all 7
but-
hours.
The notion of publishing nearly 10 hours of
Video is silly.
interview is, I don't think it's productive. I think it's a waste of the jury's time.
That's what the defense wants.
Okay.
The prosecution's allowed to play, and we've seen this in other cases. We just saw this in Banfield, where the prosecution played a part of a body cam, and then the defense was like, well, isn't this body cam video an hour long? Yes. Okay. And then the hour-long body cam goes back with the jury, and the jury sees in court the 10 minutes or so that's the most relevant. And then they have the rest of it if they want to watch it, which is what Bloodworth is suggesting here, which is a regular and common practice. If you want the whole thing admitted, fine, but we'll play the portions we choose to play. You can't make the state publish 10 hours of video hoping that the point of the video gets lost in the sauce. You can't force them to do that.
Ms. Liz.
We object to it all going back.
Sure,
It's
we're
the
aware.
same problem. The problem arises is the same as, well, let me rephrase.
How is it different publishing it in court and sending it all back? Oh, because you want to punish the jury to sit there. If it's published, it still goes back to the jury. If it's admitted and published, it all goes back. If it's admitted and partially published, it all goes back. You don't get to just have your point.
Ms. Liz.
We object to it all going back. It's the same problem. The problem arises is the same as, well, let me rephrase that. The jury's been told they're to rely on their memory of witnesses. If the whole thing goes back, they can go over and over and over her statements on the video, which is not what they can do with any other witness. So if it comes in, it needs to be published, and then they have to rely on their memory just like they would with any other testimony.
I appreciate that position. Why are we publishing all of it rather than just the parts or some parts
Okay, right.
of
Then
what
we
the
circle
state is
back to
designating?
here.
Because there are, I mean, I already made my issue or raised the issue about the May 10th.
We'll get there
Transcript.
specifically. Any others?
Yes. I would have to go through, I have gone through, but to go through right now, every specific part. But there's a lot that's being left out, and what's being left out are the statements where officers are telling her about what she needs to do in order to not have to go to jail, what kind of deals they're willing to make for her, what she needs to do and say, and that's not included. And yes, some of it she was cross-examined on, but there's a lot more statements like that she was never cross-examined on.
Well, that's choices defendant made, though. So here, in order for me to include additional material, there has to be some basis. Is it a Rule 106 request?
Yes, but in all fairness, the choice was made because that was all that she was questioned on in direct examination. Had there been a redirect back to where I started, then I would have chosen other.
You had to know that when you were doing the cross and pointing out a recent fabrication or insinuation of a recent fabrication or prior inconsistent statement, that the state has a multitude of ways to bring this in. You're just mad they clocked it. That was a tactical decision. You just don't like the repercussions of the tactical decision. You made a tactical decision. This is why questioning needs to be careful. If you try to clock Lauber on recent fabrication, then they can bring in the IO to clock it back the other way. That happens in like every case. This isn't new or unusual or weird. This is just trials.
Other portions, but I have lost the opportunity to do that.
You haven't.
No, you haven't.
That's okay. You can certainly have
I'm going to
access to
start
this
squeaking.
witness.
Well, I think we've made our record on that.
Are there Rule 106 portions you want to add, having reviewed the designations?
I think we need all of it. I think the jury needs to see exactly what her demeanor is, how she acts with the officers, how the officers treat her.
Need and want are not the same.
There are numerous other parts of this transcript that may come in through Detective O'Driscoll. I don't know yet. I mean, I don't know the answer to that fully yet, but there are a lot of other statements by both Detectives O'Driscoll and Detective Maynard that go to show that she was unduly influenced.
Then what portions are those? What the court would like you to say is there are numerous portions of these videos. We want this portion, this portion, this portion, this portion. The all is the problem. You've got to narrow down the parts you're asking for. That's what he's asking you for. Narrow it down then.
There's a lot of it.
I know, but you're not giving me which ones they are.
Keep reading, Emily.
I mean, all of them.
Okay. All right. That it's hard
No.
to rule on because it can't be all.
Right, it's not going to be all.
Well, certainly your position isn't that every single statement made by the law enforcement officers and every single answer is evidence of undue influence.
It shows an arc.
That's the state's point.
Right. I know. And now if we're going to do part of it, then we need to show the whole arc.
That's not how Rule 106 works. I need you to be more specific.
I don't have specific outlines right now in the 1,000 pages of transcripts as to what we would want and what we would.
This issue started
I mean,
last
we want
week.
all of it. If you want me to go through all 1,000 pages again and try and figure that out, I mean, guess we can find some time to do that. But
Okay. So, Mr. Bloodworth,
Oh my God,
as
I
for
can't-
today, how does the state propose to proceed?
The jury is still out. And the judge is just like, what are we
So
doing?
I propose we call Chris Kotrodimos. I then will call Jeff O'Driscoll. We will get to maybe, 45 minutes into his argument before this will become an issue.
Okay.
The court is now just stuck.
My sense on timing, Your Honor, is this doesn't become an issue till a lunch break.
I'm not sure what's going to change between now and then, though, in terms of the issue of whether to play everything or just the parts that the state has designated under Rule 801D 1B.
Fair.
So,
Right.
All right.
Oh, boy.
The issue before the court is the state's motion to admit redacted exhibits 8-57R through.
For all of you just coming in, they started the morning dealing with legal issues. They continue to deal with legal issues. They have gone round and round on things they have talked about numerous times before. And the court is trying to now synthesize what's going on. So for those of you that are like, Emily, what is going on? This is what's going on. The court sounds like he's about to synthesize it.
All right. The issue before the court is the state's motion to admit redacted exhibits 8-57R through 8-63R. The state is offering what it views as narrowly tailored portions of the transcripts of Ms. Lauber's prior interviews with law enforcement investigators and other government agencies as evidence of prior consistent statements by Ms. Lauber under 801D1B to rebut an express or implied charge that when she testified in open court in this case, she acted from a recent improper influence or motive in so testifying.
Right. The court has ruled that
In
this can
response,
come in.
defendant
It's just how.
does not provide a sufficiently specific argument that the state has over-designated any of these portions beyond what would be permissible under
that's
801D1B.
that.
And though defendant makes a Rule 106 argument regarding additional portions that would be necessary to provide context for, explain, or qualify Ms. Lauber's statements, their position is that all of it does. And that does not provide the court with a sufficient basis to rule one way or another whether other additional
Are you going to give them more
portions of
time?
these prior interviews are required to be included under Rule 106. Based on the record currently before the court and the procedural posture that brings us to this point, the state's motion to admit redact exhibits 8-57R through 8-63R is granted to the following extent. The state may publish these exhibits and use them with witnesses that are on the stand. Sitting here today, the court is not prepared to rule and does not rule that 8-57R through 8-63R may go into the jury room as admitted exhibits under Rule 17K because, sitting here at the moment, the court determines that they should not, in the opinion of the court, be in the possession of the jury to make absolutely sure that the jury does not give undue influence to these specific portions of a single witness's testimony as compared to the testimony of all the other witnesses.
So he's reserving ruling on that.
Mr. Bloodworth, anything further on that?
No, Your Honor.
Okay.
Ms.
So,
Yes, Your Honor.
so he's reserving on that issue. Okay.
We
So where
actually-
are we at? The judge reserved ruling about what goes back to the jury. That's the thing that is making him uncomfortable, that it might give undue weight because other transcripts are not going back. So this transcript would, he worry, give undue weight to what's in the transcript vis-a-vis what was in court. And the judge has said, this is coming in. The defense has not made sufficiently specific objections, delineations, notes about what they want in. They just said all of it. And he's like, okay, well, you know, up where? Whatever. So the court is back to exactly where we began, which is what the prosecution wants to be published is being published, and the court still doesn't want it to go back to the jury room. That's where we started. Okay, and the court said, anything else, Mr. Bloodworth? No. Anything else, Miss Lewis? And she was grabbing the mic and saying something.
Move for a continuance.
Motherfucker, what are you saying?
Further on that.
No, Your Honor.
Ms. Lewis.
Yes, Your Honor. If we actually would move for a continuance because we need to go through all the 1,000 pages again and figure out what portions should be let in. If the court's not inclined to let all of it in, then we don't have anyone in the cry room doing this for us. So we need time to do that. So we'd ask for a 2-day continuance.
I'm sorry. I'm sorry. I know I haven't gotten enough sleep during this trial, but I did not just hear you correctly. I did not just hear you correctly.
Further on that.
No, Your Honor.
Ms. Lewis.
Yes, Your Honor. If we actually would move for a continuance because we need to go through all the 1,000 pages again and figure out what portions
Corey's
should
head
be
just snapped
let
up.
in. If the court's not inclined to let all of it in, then we don't have anyone in the cry room doing this for us. So we need time to do that. So we'd ask for a 2-day continuance.
I'm sorry. And now you want a 2-day continuance? Also, why are we calling the witness interview room the crying room? It's not figure skating. Why is everyone stealing my Olympic analogies? It's not a kiss and cry. First of all, you have a million people on this defense team. Second of all, this came up before the weekend and you had Friday off. You knew. I can't believe that after all of this, we are now at a request for a 2-day continuance. What the fuck is happening? Did you see Corey's head? We're going to play that one more time because Corey's like, what do you mean a 2-day continuance? We're going to play that one. I am buffering. We're going to just play that one more time and then I'm granting your motion for code red. What the fuck is happening today?
The testimony of all the other witnesses in this case. Mr. Bloodworth, anything further on that?
I'm
No, Your Honor.
buffering.
Ms. Lewis.
Yes, Your Honor.
She's buffering.
We actually would move for a continuance because we need to go through all the 1,000 pages again and figure out what portions should be let in. If the court's not inclined to let all of it in, then we don't have anyone in the cry room doing this for us. So we need time to do that. So we'd ask for a 2-day continuance.
2 days.
Yes.
Your request for a 2-day continuance is denied. I don't have a basis to use that much time of the jury when this motion was filed 2 days ago and I raised it with you yesterday morning.
Okay, well, the court's denying that. I'm still going to code red. Your motion, chat, your motion is granted, even if the defense is getting immediately denied. Your motion is granted. Because what the fuck is happening? If you are new here, chat, and you are flash sensitive, code red is our code. What the fuck is even happening right now? It is flashy. It ends when the music ends. It is my favorite. Also, it breaks my brain. But what the fuck is happening? She's just like, yeah, we want 2 days, Your Honor. We just want 2 days. We would like 2 days. No. But chat, your motion's granted. We're going to code red in 3, 2, 1. All right. I backed this up a little because the judge is going, what the fuck? I'm going, what the fuck? Y'all are going, what the fuck? The judge is making a record now of when this was originally brought. Miss Lewis is just like, yeah, we just want 2 days. The court's going to, no.
Your request for a 2-day continuance is denied. I don't have a basis to use that much time of the jury when this motion was filed 2 days ago and I raised it with you yesterday morning.
Was it only yesterday morning that it was raised?
Your request for a 2-day continuance is denied.
All right, a 1-day continuance. then.
Jesus, dude, what are we horse trading? I got 2, I got 2, I got 2, I got 2. You got 2 in the back, I see 2 in the back. What about 2 and 5? 2 and 5, I want 2 and 5. I got 3, I got 3. You got 3 in the back, we got 3 in the back. We want 4, can we get 4? I see 4. Where do I see 4.5? I see 4.5. Lady in the hat. What the fuck is happening? What is... I got 2, I got 2, I got 2. No, 1. We got 1. We got 1. We want 1. Your Honor, 1. Can we get 1? You know, I went down to the Grundy County auction and I saw something I just had to have. My head told me I should proceed with caution, but my heart said, go ahead, make a bid on that. And I said, hey, pretty lady, won't you give me a sign? I'll do anything to bring you by no mind. I'll do your bidding and be at your beck and call. We've gotten all the way back to Grundy County auction, friends. What is happening? Okay. Can we do 1? Let's do 1. Sure. Let's do 1. We can't have 2. Let's do 1. Sure. Let's do 1.
Your request for a 2-day continuance is denied.
All right, a 1-day continuance then.
To tomorrow morning.
Yes.
And what is it you're going to do between now and then?
I guess we're going to go through the whole transcript and find out what we want included under Rule 106.
And you're going to file something so I can read it?
Yeah.
Press X to doubt. The judge's face is like, I don't believe you. Going once, going
Your Honor, the
twice.
state objects. Not only did the state file the motion 2 days ago with the specific portions, this whole issue was teed up last week when Carmen Lauber testified.
Yep.
I don't think there were any surprises in the motion, and I think the state's motion and the redacted versions it filed were probably what everybody expected.
Yep. They've had all this information since Carmen Lauber made these interviews.
All right.
And I said, hey,
And
pretty
Ms.
lady, why
Lewis,
don't you give me a sign?
you'd
I'll do
be
anything to make you mine on mine.
Filing something in writing that had additional
Do your bidding and be
either
at your beck and
Rule
call.
106 inclusions or
We're going to
some
give him 1?
identification of where the state has over-designated things,
Oh,
correct?
boy.
And your position would be that additional parts of the transcript should be shown to the jury, is that right?
Yes.
That is so slow.
Yeah, it
There's
is.
just no way
Yeah, it
this
is.
is going to work. There's no way we can edit the video.
I'm not tracking, Your Honor.
I mean, that's going to take a
Each
day,
of these,
too.
Transcripts corresponds to a video of an interview, correct?
Correct.
It would
I'm
seem
going
that watching
once,
and listening
going
to the video
twice.
is more efficient than reading the transcript.
Lady in the
100%,
second
Your
row.
Honor.
She's
Based
an
on
H,
the
she's an
ruling
I,
right
she's an I,
now,
she
like
got ruby red lips, blonde
2
hair,
minutes
blue eyes.
ago, we have launched
I'm about to bid my heart goodbye.
our video editor to create the video now of the narrowly tailored portions. That's how we would publish them. Is by playing the video.
Okay. All right.
One suggestion could be if the state
Ma'am!
wants to hold off on publishing all of this and see where they get with their testimony of Detective O'Driscoll.
Okay, that's
then
not a
maybe
terrible-
Through
that's not terrible.
appropriate direct examination, they can get in the portions they feel are important, and then maybe none of this would be necessary if that decision could be held off. And then if at the end of the day they still want to publish the whole thing, then we would ask that we not hold court tomorrow so we can do that. I think that would be more efficient.
Maybe.
Your Honor, we're going to want to publish it.
Okay.
Let's just cut to that chase.
Well, the auctioneer
All
was
right.
going about a mile a minute.
Folks, give me
He was
5
taking
minutes.
bids and
Actually,
calling
just
them
give me
out
till
loud.
11.
And I guess I was really getting in
Okay.
it. Cause I just shouted out
We're
above the
recessed.
crowd. And I said, hey, pretty lady, won't you give me a sign? I'd give anything to make you mine, oh mine. I'll do your bidding and be at your beck and call. Never seen anyone looking so fine, man. I gotta have you. Wait, no. Man, I gotta have her. She's one of a kind. I'm going once, going twice. Sold on the lady in the second row. She's an 8, she's a 9, she's a 10, I know. If all of you did not listen to 90s Country, I apologize. Go track down Grundy County Auction immediately, because apparently that's what we're doing right now. Okay, so the court's taking 5 minutes. Emily, what do you like to sing? Karaoke. Well, Sold is up there. So we have now discussed the Carmen Lauber interviews. There's like 10 of them. It's apparently like 7 hours of interviews. Starting last week. Because when Carmen Lauber testified, the defense insinuated and directly said through their cross-examination that Carmen had made up statements, had recently fabricated statements, including, oh, but this is the first time we're hearing about this third transaction. You're just saying it because law enforcement just told you what to say. So you're just saying it, among other things. And so this came up last week, and the prosecution was like, hey, we have had a chance to go back and review. We're taking a little looky, and we think that there are statements, like they did with Robert Crozier, there are statements that can come in to rebut the defense's questioning and insinuations regarding Carmen Lauber. They filed a motion about it to all of a heads up, and then they talked about it in court, I think yesterday? I thought it was last week, but maybe yesterday, because who knows what days are anymore. They're not real. And we started this entire conversation with the prosecution saying, we want to send back these parts of the transcript, let the jury read them. The court does not just want to send back the transcripts because no other transcripts are going back to the jury. And in fact, there's an instruction that they're not going to get them. The court asked, can't we just play the video? And the prosecution was like, okay, but we've got to edit all of that, and that takes some time. So we were just going to publish versions of the transcript. I think playing the video is probably better. But I also understand the time that it's going to take. So the defense said, well, if the prosecution's going to narrow this down from 900 pages to 100 pages, we don't want them to have any of it. And then it was not only we don't want them to have any of it, they have to bring it in through Carmen Lauber. So we went all the way back to the beginning of it has to come in with Carmen Lauber and got all the way back through the case law again, saying, no, it doesn't have to come in with Carmen Lauber, the same way we did with Robert Crozier. We went all the way back to the beginning and all the way back to where we were with Crozier. It doesn't have to come in that way. The court made a very thorough record about that. And then the defense is like, well, fine, then we want it all in. And the court's like, how would you like it all to come in? Send 900 pages back to the jury room or sit in court and publish it? They're like, play all 7 hours. Prosecution's like, Your Honor, we're not gonna play all 7 hours. We don't have to do that. We want these narrowly tailored portions. And the judge looked at the defense and said, can you tell me exactly what portions are needed for? Are you asking for it under Rule 106 completeness? And the defense is like, yes, completeness, all of it. The court said, can you specify what needs to come in? All of it. The court's like, okay, let me just make a ruling. Since we cannot specify, and the defense is not specifying, the way that the prosecution wants to do it is coming in. I am not ruling, the judge said, I am not ruling that this is going to go back to the jury room. It might just be presented in court as testimony and not go back to the jury room. And the defense said, we want 2 days. The court already ruled on what's coming in, just not if it's going back to the jury room. And the defense said, we want 2 days. We want a 2-day continuance. The court buffered again and then said, huh? This issue, first of all, you've had these interviews and transcripts. You've known that Carmen Lauber was the key witness in this case. This is how this works. You know that it's not a shock if you are going to insinuate or directly accuse a witness of a recent fabrication that their interviews can come in. This is not new. And so the judge is like, well, this issue was specifically raised in filings like last week, and we talked about it yesterday. What more is going to get done in 2 days that can't be done now? And the defense is like, well, we don't have anybody sitting back in the witness room. She called it the crying room, but the witness room working on this for us. So we need 2 days. And the court's like, yeah, no. 2 days isn't going to work. And then the defense attorneys look at each other, except for Ramos, who's sitting at the end of the table like, I don't even go here. And the other two are like, let's ask for one. Let's ask for one. Yeah, we'll ask for one. Your Honor, we want one. And the court's like, so from now till tomorrow morning? And they're like, no, let's get through where we get through in the testimony today, and then we'll take tomorrow off. And the judge is like, I don't think that's what we're going to do. And looked at the prosecutor and was like, can we get the video edited? Can we just fix this with the video editing? And the prosecution's like, we have an editor. We can work on it. It's 7 hours. It's a lot to edit. And the court's like, I'm going to need 5 minutes. So the court takes 5 minutes. I don't know what happens next. I guess we're going to find out. The judge is buffering. I'm buffering. The defense is just like, we'll just get more time. That's why we're on code red. And so the court went back to the chambers to break stuff. I can imagine the judge. The judge is so patient. Do you think the judge goes back and puts on his call map? Or like Endel and is just like, or do you think it's like a full woo-saw? Or do you think he's just sitting there with his, you know what, Your Honor? I've got a suggestion. We'll send you one of these. The big pens they're really helpful. And you could just go back to chambers and just be like, ah! Maybe we just, no, click, click. I picture the judge just sitting cross-legged with his like noise canceling headphones and makes himself like an Earl Grey tea. And it's just like, I need to go center myself. Or maybe the judge has a door, a little patio, takes off the shoes, goes just literally stands in the grass and is like, woo-saw, little downward dog, little breathing exercise.
And for defendant are present. Defendant is present.
And now we're
Ms.
back.
Lewis, the
jury's
defendant
still out.
Asked for a 1-day continuance to allow time for defendant to, on the one hand, review the designations made by the state, determine whether there are some over designations that go beyond what should be published under 801D1B, and also to offer additional designations that in the defendant's view should be included under Rule 106. That request is granted. We need to come up with a set of deadlines by which defendant will take those positions in writing, by which the court and the state can review them.
Oh my God.
By which we can have a discussion on the record about which of defendant's positions are persuasive. And if possible, Mr. Bloodworth, and I know I don't have any control over this, I'd really like to build in time for the state's video editor to take whatever I decide and turn it into a video so that when we're publishing a video, not just pages of a transcript. Let's work backwards from there. Mm-hmm. How long is that process?
Bloodworth is like, fucking
and if you need
hell.
to take a moment and step out and tell your video editor to press pause, I'd understand.
So
the state is just like, you've got to be kidding me.
the state will, within an hour or two,
They will do their best.
maybe within 3 hours, have the video that corresponds to the status quo of the 6 exhibits.
That's so stressful.
Now, depending on
That's so stressful.
how much additional comes in and how much additional goes out.
Right.
That's going to take more time.
Hard to say. 4 hours?
Additional.
Okay. All right.
But then we're going to get the defense.
As a practical matter,
Throwing
do you
shit
think
at
we
the
should
wall
start
in the
midday
morning.
tomorrow or just come back on Thursday?
Oh, fucking hell.
I was hoping to come back midday tomorrow.
So we can do that, assuming. Was the court considering a deadline from defense something like
That
6
would
p.m.
help.
today?
Yes, something like that.
If we get that at 6 p.m., my sense is by 8:30 tomorrow, the state will have a response. The court rules by
9:30.
9:30. We can probably get the video done.
Okay. Ms. Lewis.
No, Your Honor, they don't want a solution. They want a recess. Miss Lewis, the court is talking to you. The court is not talking just to talk.
We're just discussing. I don't think we can get it done by 6.
I don't understand why.
Yeah, what the fuck?
The transcript is only this much stuff printed in 12 point.
I can't even believe that the court is entertaining this at all. But the court has been incredibly accommodating to defense. Oh my God. They're just every time the court comes up with a solution, they're like, and then this, and then this, and then this. He's like, solution A. They're like, B. Solution B. X. Solution X. Z. Solution Z. Back to B. Every single time.
We're just discussing. I don't think we can get it done by 6.
I don't understand why. I mean, the transcript is only.
Okay, first of all, Kouri Richins has a little snacky poo at counsel table. Let's start there. He has got to be so frustrated.
Discussing. I don't think we can get it done by 6.
I don't understand why. I mean, the transcript is only this much stuff printed in 12-point font.
But
The Rule 106 designations would be immediately before or immediately after. And to the extent you're going to de-designate it, you're just taking stuff out of those. So it's a relatively focused inquiry.
Yes.
You can go back and watch Carmen Lauber's entire cross and
On 2x speed.
direct and cross on court TV at 1.5 speed to refresh your recollection of what she said on the stand in order to determine whether this is consistent or not. To the extent you want to get more beyond this, I'm not sure you're entitled to do that.
I don't understand. What
Well,
you mean.
if, for example, there's 200 pages of interview with Jeff O'Driscoll the first time, and the state's just trying to put in 20 from the beginning, you don't get to skip to the end and say, well, these last 40 would be really helpful to us.
Right.
We made a strategic choice not to ask Carmen Lauber
Right.
about them when she was on the stand, but
Right.
we'd like to put them in now. That's not this exercise.
I'm not sure I understand what you mean. The portions of the transcript that they pulled out are
Ma'am.
from portions of all 7 interviews.
I agree, but they're just portions that are prior consistent statements. And so
What the court is saying is if there's only 20 pages from this transcript, you only need to look at the immediate surrounding pages for completeness. You don't need to read the whole transcript. What are the pages they're asking for? What are the 2 pages in front of and the 2 pages behind? That's where you start. You can't just skip to the middle of it and then say, we need this too. Completeness means surrounding the parts that are being admitted. So if it's page 5 to 25, the inquiry is page 1 to 30 generously. That's it. This is just
over designate. This goes beyond a prior consistent statement.
Wild.
Or is there some stuff immediately before or immediately after under Rule 106 that's required to qualify, provide context, or explain?
Your Honor, can I add a small wrinkle to that?
Sure.
In addition to prior consistent statement, it is rebuttal on recent motive to fabricate.
Yeah, that is the same. That's
Section.
that's the prior consistent statement rule.
Right.
Yeah, I think there were two separate things in 802D1, but maybe we're saying the same thing.
801D1B.
I mean 801D1, yeah.
Is consistent with the declarant's testimony and is offered to rebut. So
Right.
it's the same rule.
Okay, got it.
I don't see you doing prior inconsistent statements based upon
No.
a lack of memory.
Nothing in A.
Right. I think we see it the same way.
Okay.
We have till 11 p.m.
No.
No.
I need time to read it. The state needs time to read it.
11
possible.
p.m.?
I want to make sure.
Why are we sandbagging at this point? Can we have till 11 p.m.? No. They want the state to not be able to get it edited, it seems to me. Why? What? Can we have till 11? No, you cannot.
That we have a common understanding of what you'd be permitted to do under 801D1B and Rule 106. This is not an opportunity to recross Carmen Lauber. If you want to recall her, I'm not making any statement about that. But to the extent there was stuff you wanted to put in your cross that you didn't, you're stuck with that for now until you recross her. If, on the other hand, there is an over-designation by the state under the bounds of 801D1B, I need to know. And if, in defendant's view, there's a
Completeness under
Rule
106
inclusion that's required before or after these designations,
It's like
I
telling
need
a
to know.
student their assignment 17 times and they're still like, so it's this? No.
Understood.
Really?
Okay. So 6 p.m., we need it in writing, filed in the case, please. If you would separate out what you believe need to be de-designated versus what you need to be, what I think needs to be added under Rule 106, I'd appreciate that. We'll reconvene at 8:30 tomorrow morning. Yes, Mr. Bloodworth?
Yes, sir.
Okay. Now, in terms of how to proceed for the remainder of today, do you
Oh
want to
my
put
God.
Kotrodimos on and get him done, or do you want to break now?
Are we getting to a witness?
Your Honor, if we can call him, he's 10 minutes.
Okay. Any objection, Ms. Lewis?
Oh, they're asking now they want,
Time.
All right.
Oh,
they're like, okay, well, if we're calling another witness, we need more than 6 p.m. Right.
okay.
He's only going to be 10 minutes.
Yeah.
All right.
Take an hour.
Okay. Got it. And then we'll invite the jury to come back at 1 p.m. tomorrow. Does that
Oh,
sound
boy.
reasonable?
Yes, sir.
Oh,
Okay.
boy.
Very good. Anything else before we invite the jury in, Mr. Bloodworth?
No, Your Honor.
Ms. Lewis?
No, Your Honor.
Okay.
Okay, well, I guess we're getting to a witness. Can I get a witness? Sure. We're getting to our next witness. Miguelina, will you let the app know that we are getting to the first and only witness of the day? And that's what we're doing today. And then they are going to recess early for the day, it seems. So I guess as this witness comes in, we're going to go back to our stream colors. That was crazy. All right. So witness coming in, jury coming in for 10 minutes, it seems. And then we're done for the day. That's quite a day of court. Okay. I'm going to zoom past this. Miss Lewis just seems mad. Are we gonna? All right, here's the jury.
Have a seat as you come in. Thank you.
Wow. What a wild morning. What's the judge gonna say to the jurors? I'm so sorry. I imagine.
Have a seat. Thank you. Ladies and gentlemen of the jury, I greatly appreciate your patience while we
I'm
work
so
through some legal
sorry.
issues. We will proceed with a witness from the state, and then I have some scheduling notes for you. Mr. Blow.
Boy.
Oh, Ms. Sherman, my apologies.
No problem, Your Honor. Chris Kotrodimos, please.
What a wild freaking day.
If you step in front of Brittany.
Wild day.
Do you solemnly swear the testimony you're about to give in the matter before the court to be the truth, the whole truth, and nothing but the truth, subject to the pains and penalties of perjury? Thank you. Have a seat. Good morning.
Good morning.
Although the jury knows who you are, I'm going to have you state your name and spell your last name for the record, please.
It's
a
Chris
recall.
Kotrodimos, Kotrodimos.
Now, we brought you back to talk about a couple specific issues. We know from your prior testimony that when you reviewed data from Eric Richins' phone, specifically for February 14th, 2022, you looked at the Verizon call records.
Correct.
Those included
Oh.
text messages.
They did.
And
Oh.
that's the raw data that we talked about throughout your testimony.
Yes.
Is that right? And tell the jury, for an outgoing message from Eric Richins, how would Verizon list that time zone in their record, in their call record, that raw data?
It would depend on what type of message it was. For an SMS text, which is just a normal type text, it would route it through their normal server. It would be in local time. For MMS, that message has to be routed through a server, and so they use the server to route that call, and it would have a timestamp for the location of the server, not necessarily the device.
So when you looked at those records, the outgoing messages for Eric Richins' phone in
Remember, the defense brought this up yesterday and really specifically called out, wasn't Eric Richins sending this text on February 14th? And they gave a really specific time to that. And so it seems that this is circling back to what we heard yesterday when the defense was getting into the detailed times from the call records with the PI yesterday. Because I was making notes of, she kept saying exactly what time. And I was like, are we going to talk about it? Are we going to get to the time? No, Chad, unfortunately, it wasn't 2:27. It wasn't the 2 p.m. hour, though, I think.
the Verizon records, what time was reported for an MMS outgoing from Eric Richins' phone?
So there was an outgoing, in the record, there was an outgoing MMS at 12:23 p.m.
Would that be 12:23 p.m. in Utah?
No.
So what would the time of that outgoing message be for us in Utah?
We're 2 hours behind, so it would be 10:23 a.m.
Scott, if we could put up 3-14D, please.
Oh, you're right. I
This
forgot.
was previously admitted.
I forgot to fly when the jury came in. I was discombobulated.
We can publish it to the jury.
We'll fly after this witness. Sorry, chat. I completely forgot. But the defense, I think, was trying to put these text messages right in the middle of when Eric Richins was not active on the phone and was trying to show that there were texts happening during that window where Eric Richins was not active.
We entered this exhibit through your testimony last time, and we talked about this gap.
Keep reading, Emily. The defense was asking the witness yesterday about this gap when it seemed that Eric might have been napping based on the text messages. And so a text message at 2:23 p.m. would fall right in the middle of that 12:05 to 1:32, which goes to the attempted murder and whether or not Eric Richins was actually feeling ill enough that he was kind of out of commission during that period of time. they were trying to raise doubt, I guess, with that by saying, oh, but you saw these text messages happening. Well, those were MMS messages, and that's not the time. So here we are with this witness coming back to close that circle.
An activity from Eric Richins' phone. And so what you've just described conforms with the raw data. Is that right?
Yes.
And describe it again now that the jury can see the time frame we're talking about. If a call record or a text message MMS showed outgoing from Eric Richins' phone at 12:23 in the raw data, you confirmed that that would have been 10:23 in Utah.
Correct.
How did you verify that?
So, one, just the knowledge and experience of knowing that that's how Verizon routes MMS messages. They use an Eastern time zone, which is consistent with their headquarters location. So to verify that, for time zones are very critical for analysts, obviously. What you would do is, if you have a source to look at the original text, and in this case we do, which would be Eric Richins' cell, his phone extraction, his cell download, I would expect to see, based on the time difference, an outgoing MMS text at 10:23 a.m. versus 12:23 p.m. And I did find that there was an outgoing message at 10:23
saw it on the phone.
a.m., an MMS message to that number, and it was a photo.
So essentially, through your analysis and changing the time zones as necessary, this exhibit is still accurate.
Yes.
So it's closing that loop from
Scott,
Cross.
if you could put up 3-39D on
And he's
page
closing
5,
the loop
please, for the witness. This
from
has previously
looking
been admitted.
at Eric's phone.
And you can publish it as well. And you can blow up one of those messages or... So now that we're talking
Right.
about time zones, describe for the jury how we get to the times that are listed in all of these text bubbles. And so that the jury knows, all of the messages that we have entered have these timestamps on them.
They do, yes.
And how do we get to the time that is on there?
Okay.
For those listening in the background or, stress cleaning your house after this morning, they have pulled up some of the text between Kouri and Grossman on the Celebrite extraction to talk about the times on the Celebrite extraction.
Time zone issue again. Okay, so phone extractions from software are provided, those readable files are provided in UTC 0. So to determine local time of when that
They're
activity on the
filtered
device
through
happened
UTC -7.
at the local time, you have to adjust. So Utah is -7 UTC during normal standard time. It is -6 UTC in daylight savings. So we just switched on Sunday. So now everything until November, when we switch back
Will be
again,
UTC
will be
-6.
-6. So the -7 and the -6 denoted in these messages is a adjustment that is made by the software to denote local time versus software time.
Right.
So for each of
So
the
the reason those say UTC -7 is because they filtered, because that was where
Messages
we
that-
pause. Everything that was provided with UTC 0. And then they go through and filter it UTC -7 for the report.
the state submitted
Yes, we have now gotten back to 6-7. We have now gotten back to 6-7.
So the -7 and the -6 denoted in these messages is a adjustment that is made by the software to denote local time versus software time.
So for each of the messages that the state submitted in this case, they have been adjusted to local time.
Yes.
Okay. Those are all my questions.
Sure. Thanks.
Mr. Ronney.
No questions.
Okay. Sir, you can step down. Thank you.
Thank you, sir.
Okay. And no cross
Counsel will
from
proceed
Ramos.
with the scheduling notes, correct?
Yes, Your Honor.
And now the jury is
All right.
going to hear
Ladies
that
and
they're
gentlemen,
done
I
for the
appreciate
day.
your patience this morning.
The judge is so
We've been working
stressed.
very hard on some legal issues that will materially increase the efficiency of the presentation of evidence going forward. I know it's hard for you to know that, not being in the courtroom. I'm just asking you to take my word for it. We have more work in that regard to do. Rather than have you sit here while we do it, we're going to send you
Bye-bye.
home for the day and not ask you to return until 1 p.m. tomorrow. So we will recess until 1 p.m. tomorrow. As always,
So no lunch. You
during
guys
this
are just gonna
period
roll
of
straight
recess,
through
please
tomorrow.
do not speak about the case with anyone. Do not allow anyone to speak about it with you.
Wow.
Please do not watch, listen, or read anything about the case. Please do not do any research of any kind. I greatly appreciate your patience. Travel safely. 1 p.m. tomorrow. Please rise for the jury.
Well. The jury's just like, I imagine the jury's got to be like, what in the ever-loving. Oh no, we will be streaming tomorrow because the lawyers are going to be back arguing about this more in the morning. The judge gave that much time for the lawyers to finish arguing. So no, we will be streaming tomorrow. I'm just going to keep an eye because if there is a massive gap, we will start streaming so we have Zoom room. But no, we'll be streaming
All right, folks,
for
have
the
a seat.
lawyer arguments tomorrow.
Mr. Bloodworth, anything else on the record
This is why
today?
we do this behind time.
Your
so we have
Honor.
Zoom room.
Ms. Lewis. Ms. Nestor.
No, sir.
Mr. Ramos.
Thank you, Judge. No.
Okay. 8:30 tomorrow morning. Please travel safe. We'll be in recess. Thank you.
Okay. And that's the end of day 11. Not what I anticipated from court today. So just about, let me take a look here. What about 3 hours of court barely today? About 3 hours of court today. Which we've been streaming for 3 hours and 20 minutes. They had some really big gaps in the day where the court was in chambers. So they weren't even on the record for 3 hours today. And that witness was 10 minutes to clear up timing. So since we have an extended layover, I'm going to let y'all fly home and we're going to have an extended layover. Well, less for us because we're going to be back when the lawyers are arguing tomorrow. We're going to answer some questions and then we're going to just try to summarize what the fuck happened today. So for those of you that have joined us at any various point in today, this is one of those days when the wheels just come all the way off or the shark is jumped or whatever analogy you would like to use. Pick an analogy, any analogy for shit going fucking sideways. It'll work. The beginning of the day started with the lawyers coming back at 8:30, the jury coming back at 9:30 to prepare for Detective O'Driscoll's testimony. Detective O'Driscoll is likely the last, if not the last significant witness for the state. They might have another witness or two tying up loose ends like Kotrodimos. They might not. But the last significant witness for the state. Through O'Driscoll, we're going to see Kouri Richins interview, the jail calls, the walk the dog letter, and the rest of it. So they were going through and fine-tuning what was in, what was out, what was going to be redacted, what might be unredacted, based on how the evidence has developed so far. And you saw the attorneys on both sides at some point say, yeah, we withdraw that. No, we would like that redacted. No, we would like this unredacted. And then, after all of that happened very normally, we got to Carmen Lauber. And when we got to Carmen Lauber, we got to a wild, disjointed, circular argument that has happened in the days before. And it was very similar to the arguments that we saw regarding Robert Crozier. So we are now deep into the rules of evidence. And the prosecution said, Your Honor, since the defense brought up in cross that Carmen Lauber had recently fabricated statements, was motivated to fabricate statements, and had made prior inconsistent statements, we are allowed to rehabilitate that witness with prior consistent statements and show some of her interviews. The prosecution narrowed down the 900 pages of transcripts to 100 pages of transcripts. And the court had previously ruled with Crozier and indicated with Lauber that that can come in. The defense previously argued that has to come in through a witness. You remember these arguments with Robert Crozier. These has to come in through a witness. And the prosecution's like, no, we're just going to play the video. We're just going to just roll that video that doesn't need to come in through a witness. Because you had the videos and because you had the opportunity to cross-examine Robert Crozier, we're just going to roll it. And that's what they did. And that's the same position we're in with Lauber, except the prosecution said, well, we have a transcript and we want to be able to send the transcript back with the jury. And the court's like, I don't love sending the transcript back with the jury. Are there other options? And the prosecution's like, editing down these videos without a court ruling is going to take a ton of time. It's like 7+ hours of video. We need a ruling so we're not redacting, unredacting the video. We don't want to cut and then recut video. It takes time. So the defense argued again that Carmen Lauber has to take the stand for the prior statements to be allowed in. And that went round and round and round for a moment. And the court said, no. We're not doing this again. You do not have to have the witness on the stand who is the declarant, the one who said it, in order to admit these. It can be done with O'Driscoll. The defense raised cross-examination, confrontation issues, Crawford issues, and said, Your Honor, no. The court pointed out, as the court did previously, you had all these interviews before you cross-examined Carmen Lauber. You were not restricted in any way. The court pointed out more than once today that the reason this is coming up is because of the choices made in cross-examination. You chose to cross-examine this way, now this comes in. If you had not gone there and cross, this would not be coming up. You made a choice. The prosecution is allowed to make the response under the law. They are allowed to do that under 801. And so then we got to the court saying, we're not arguing this anymore. I'm just ruling. And then the defense started arguing, well, fine, if that's coming in, we want all of it coming in. And then they went round and round on if all of it's coming in for a while. And the prosecution's like, no. If you want to send all 900 pages back to the jury, send all 900 pages back. But we're not publishing to the jury all 900 pages or all 7 hours of testimony. We're not doing that. We don't have to do that. We're not going to do that. No. And so then back round and around again about what was going to be admitted and how it was going to be presented to the jury. Then we got to the court ruling that what the prosecution has submitted is coming in. The judge does not want to send the transcripts back and ask the prosecution if they can edit it. Then the defense said, well, if that's your ruling, we need a 2-day continuance, because the court in the ruling said the defense has not provided sufficient specificity on where they want to essentially embiggen the statements for completeness. The defense just kept saying, we want all of it. All. The court's like, you did not provide me any specificity. So we're admitting what the prosecution has asked for, and that's done. The defense is like, no, I want 2 days. And the court's like, no. Denied. So the defense is like, what are you? 1 day, we want 1 day. And the court's like, till tomorrow morning. From now till tomorrow morning. And then the court took 5 minutes and narrowed that down to, y'all need to file, defense, you need to file a motion by 6 p.m. tonight, and you need to delineate exactly where you are asking for prior inconsistent statements and exactly where you are asking for 106 completeness statements. And the defense is like, we can't get all that done. The court's like, I don't understand what the problem is. These are transcripts that you've had for at least a year. This was one of the state's biggest witnesses, so you're aware. And you need to evaluate the statements that the state's putting in and the context around them. That's the biggest part of this. So no, you have till 6, because then the prosecution needs to respond, the court needs to read it, and the court needs to rule on it. So then the prosecution can edit it sometime tomorrow. And a lot of you are asking, Emily, but what happens if they don't file it by 6? The prosecution is still going to get squished on having to get it edited. Yeah, the prosecution is going to have to eat it if the defense is slow, because the prosecution needs to get their witnesses done and move the case along in front of the jury. And the prosecution is the side that's going to bear that burden of having to get it done. And the court will be displeased, but I imagine the court won't do much else about it other than be displeased. I don't imagine that this judge on this issue will say, then you don't get any of your edits. I don't think the judge will do that, because that becomes an appellate issue. And so it will end up being a squish for the state. And the court will be displeased, but the court is not going to change the ruling in a way that could create an appellate issue on a key witness. The defense is kind of exhibiting the give them an inch and they'll take a mile. And the judge has been fairly patient, maybe too much so, but fairly patient with the defense and very mindful about protecting the appellate record. And there are times when I have seen the court err more cautiously towards the defense in their rulings than towards the state. Remember, the state can't really do much about it. So what can the state do? The state can say, Your Honor, we need a little bit more time to edit the video. And the court says, fine, you can play the video at the end of the day then. Instead of now, somebody can work on it. The state can't appeal it. And if she's acquitted, the state can't appeal anything. And if she's convicted, the state can't appeal anything. So the state ends up getting a little bit squished on that. The state, again, has the burden. And the defense was saying the state has more resources. So yeah, the state gets a little squished on that. I think that the court has been incredibly gracious with this defense team and has gone above and beyond at times to protect the record in this case. And the court has actually started pulling out more legal foundation from the defense. And the defense will say something and stop, and the court will add in, are you asking this, 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 and this to protect the record? And the court has gone above and beyond to assist in protecting the record in a way that I have not seen a lot of judges do. So are you saying you are asking for 106 rule of completeness, defense? And the defense is like, yes. It is frustrating to watch. I think this judge has been very patient. I think this judge has been very mindful, very demure, very mindful, very cutesy. The judge has been very mindful to protect the record, the judge has to be exhausted too. Very much mindful protecting the record, because at the end of the day, I think this judge very much sees his role as protecting the rights of the defendant. And a lot of judges, at the end of the day, will err on the side of the defense in these particularly critical trial matters to protect the record. I am very curious. The way I'm going to be sitting here at 6 p.m. Mountain Time, just refresh. I'm going to wait till that thing hits the docket. I'm going to send you an app notification when that shit hits the docket. I want to see the fucking filing stamp. So the second that hits the docket, it's probably going to be redacted. But the second that hits the docket, I'm going to send you a push notification in the app because I want to know too. Oh, my petty ass is going to be sitting here refreshing to see when they file it. You bet I will. I'll send you a notification. You guys don't have to worry about it. I'll tell you. I'll let you know exactly what time it gets filed. Don't worry. I'll send it to you. They're in Mountain Time, so 2 hours behind Eastern. Standard Time. No, shit, Daylight Time, Eastern Daylight Time. The frustration for me is the lack of preparedness, the lack of candor with the court, and the circular arguments. These are things that particularly make me, as you can tell, very frustrated. It makes me very frustrated. They knew that this was a critical witness. They had all of these transcripts. And again, 900 pages is a lot, but 900 pages of transcripts at 12-point font are not as dense as 900 pages of motion work. So it's a lot. I love that some of you are like, Emily, why don't we just sit here and chat and tell stories until 6 p.m.? I love you, law nerds. Today is a weather day. Tomorrow is a weather day, and my kiddos are on spring break. So for today, I'm going to spend a little bit of clawed back time with my kiddos because it is spring break for them. So I'm going to spend a little spring break time with the kiddos since court is done for the day. I'm going to answer some questions though. First question we got. Let's get to some questions. We haven't rolled our questions. You got questions. I got questions. We got questions for a minute. We haven't rolled it in a minute. I know you guys. Ryan Hall, y'all will be streaming for sure. Absolutely for sure. You can go watch the weather. Let's answer some questions though, shall we? So first question I've seen quite a lot is about the judge's mugs. What mugs is the judge using? What is the logo on the mug? What in the mug is happening? So I'm just going to pull it up so we can all see together. Park City High School. Chat pointed out today. They're like, I think that's Park City Schools. Yes. Park City High School. This is let's do this differently. This is the logo for Park City High School. That's the logo. That's the one the judge has on the mugs. It's pretty badass, but that's the logo for Park City High School. So that's what it is. That's what's been on the judge's mugs and everything else. Would it shock me if the judge had a kiddo in high school? No. Would I sit on the bench in a public trial with the logo of my kiddo's high school? Also no. And might it be that the judge goes and does moot court at the high school? And in fact, this is not where any kiddos go. Yes, it is very possible. So I will not speculate any further, but it's kind of badass. I imagine it has to do with like avalanches. It's Park City, snow and mountains and things. That's my guess. But anyway, it's fairly badass. I like it. So that's the logo that we've been seeing. I imagine that the judge is just, he's local. He's supporting local schools no matter what. But the pickaxes are pretty cool. So with that, what else do we have? We have lots and lots of questions, and we had lots of gifted memberships today. To everyone who gifted memberships, thank you. You continue to make our moderators' lives even more spicy with no slow mode, but don't worry. If you are sitting here watching my stream and are like, Emily, it says I can't chat. Well, I was very, very, very quick on the timing out today. So when there were spoilers, there were some timeouts. Y'all should be able to chat tomorrow. Some of you might not. There were a few that got yeeted permanently. Most just got timed out. But when we ask for no spoilers, we mean it. And Emily was feisty on the timeouts. So if you find yourself not being able to chat, you'll probably be back tomorrow. I can't guarantee that for everybody. Some of the spoilers just got yeeted, especially if they were in bad faith. The ones that weren't in bad faith just got timed out. Wolf Kiara said, how long of a timeout did you give? 24 hours. I told you all yesterday I was feisty. I said I was feisty yesterday. Yeah, I know. Doop, 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 doop. Sometime tomorrow people will be back. No, I was feisty. No. I said it yesterday. I gave a heads up. I asked twice. There are rules. I'm sure the mods were looking at the chat going, oh, she's feisty today. Yeah, that was me. It was me. That was me. Squirrely Nerdy Jess said, EDB, explain other people's, please. Squirrely Nerdy Jess, this began at the beginning of this trial because last trial we were so focused on Baby I Love You with Banfield that we didn't get to the OPP of it all. This trial we started talking about what the appropriate way to refer to Kouri Richins' boyfriend is, because I don't know, boyfriend's kind of weird for a paramour, not the band, a lover, a side piece, if you will. And so that's began the wandering into the world of OPP. And we were talking about the song OPP by Naughty by Nature and the lyrical genius that is some of the stances are, other people's rhyme, another word for cat or kitty. Some of it is other people's rhymes with leanest or meanest. I know we're working on making some of those things rhyme. It's Naughty by Nature, not me. And so when we started talking about the OPP of it all, there were some in our chat that were like, oh, I have never heard this song, or, oh, I have just now realized that when they're talking for another word to call a cat a kitty, we're talking about other people's, that last P means right. Okay. Meow. That last P means other people's meow or other people's, right. Okay. Okay. So we're going to make all those other P's fit. So we were talking about the OPP, and then the first two letters are the same and the last is something different was a challenge and embraced by the chat. So the first two letters the same or the last or something different has expanded into an entire universe of OPP. We got to other people's phlegm. We got to other people's pennies. Today, it seems that we're at other people's pickaxes. We're at other people's parlance. We were at all other people's pickles. We have had all of the OPP. So if you have not listened to OPP by Naughty by Nature, I am not feisty enough to roll the dice with the copyright system today. You might want to go do that on your own with Naughty by Nature and take a look at the lyrics. So then it just became other people's paramours, other people's prescriptions, other people's pills, other people's, we had other people's poltergeists, other people's P. Sherman Wallaby Way. So then the last P just became the thing this trial, as it does, because the first two letters are the same and the last is something different. Chat was like, I've embraced it. Yes. So that is where the OPP came from this trial. It came from Naughty by Nature and the fact that we are in another trial, another murder trial with other people's paramours. We have fully gotten back around to, baby, I love you. And I love my children. I love my husband. I have been with my husband since like 1998, 99, right on the cusp there. I would have to ask Dr. B. 98, 98, forever. Forever. The more we get to these cases, the more I am baffled by the decisions that are made. Murdaugh, I don't understand. Banfield, I don't understand. The choices that are made in these cases are hard to logically wrap your mind around when your brain does not work this way. And it's hard when we're sitting here going, what in the world is going on? Your affair clearly isn't, none of this is right, Emily. Stop trying to logic. Stop trying to logic the illogical. It's illogical. Being like, you know what I need? I need you to not have custody of the kids. So murder is the option, is not logical for most of us. For Kouri Richins, well, we'll see what the jury decides. But for Kouri Richins, the self-preservation urge is strong, which we saw in Murdaugh. I mean, we've gotten to other people's property parcels with the fucking stolen house. It's wild. So in trying to wrap our heads around the illogical, because this does not follow, there are some cases where you look at it and you're like, oh yeah, I can get why you're stealing that. Yeah, I get why you're pissed at that person. Yeah, I can kind of understand where some of these decisions came from. I mean, they're not great decisions, but I understand where they came from. And then there's some cases where you're just like, dude, y'all could have made different choices. And alas, here we are. It's a lot. But that's where OPP came from. That's where OPP came from. In this case, it's just frustrating. Texas Farm Girl asked, as a DA, did you ever have a case like this? Not for trial. I had a lot of financial cases. I would have to try to think if I had any poisoning cases. I don't think I had any poisoning cases. Most of the murders I dealt with all of the murders I dealt with were not domestically related. Domestic cases had other people's prosecutors. They had special prosecutors that were handling them. I did not handle domestic cases. So no. What was my first case as a DA? I don't know. The first day I showed up after training, there was a stack of cases like this on my desk. And I picked up the stack of cases and they're like, your courtroom is down that hallway. And you take them to court and you put them on the desk. And all the defense attorneys are like, hello. And you're like, hi, this is my calendar for the day. We're going to figure it out. I have no idea what the first one I cracked on that was. But the early days of trials, we've talked about some of those. But yes. And then the early days of felony trials, we've talked about some of those too. So let us continue on. Let's see. Music to My Soul said, Emily had a question yesterday, wanted to ask, were there ever PIs involved in cases you worked? I was curious how prosecution might feel about that. The defense has PIs in almost every case because the defense doesn't have like sheriffs or law enforcement. So the defense has PIs in almost every case, but we didn't have interaction like this. Again, the oddness of having an ongoing civil case while there's a criminal case, though different than Karen Reed, it is still unusual to have extensive civil litigation going on while there's criminal litigation. I've not seen a PI in a civil case end up a witness in a criminal case quite like this, but this case is a lot of unique circumstances because of the undergoing and underlying civil litigation. The PI was spicy, but most criminal cases, the defense has a PI who can help interview witnesses, go serve witnesses. They need someone in addition to the defense attorneys to do that. So yes, almost every case. Jada Warren said, I am very new to this case. I was wondering from yesterday, does she have different attorneys for this trial in civil? Yes, she does. She has different trials. She has different attorneys for the criminal and the civil, and she previously had different attorneys for the criminal. There was a conflict because of something that went down in the civil. I'm still not clear on what that is. It's all sealed, but there was a privately retained counsel before. That's the attorney we see mentioned in the Walk the Dog letter named Sky. I don't think there will be explanation for the jury about who Sky is. If the defendant testifies, then we might see that. But without the defendant testifying, I don't think we will see much explanation about Sky. So I will link below where I read the Walk the Dog letter. But for this, we've got, walk the dog, but take vague notes. Yep. Sky is saying, even if the gummies have fentanyl, that one. But if you have not seen the Walk the Dog letter, it's a personal choice. You can wait till after trial and let it be revealed to you, or you can go search out spoilers. I talked about this letter way too many times on this channel. It's wild. So, Nicole, the Kiwi, asked, was Sky Lazaro the first lawyer? Yes, that was the first lawyer. A lot of you are asking, will Kouri Richins testify? The defense told the court when scheduling this case that they needed enough time because the defendant would testify. The defendant can change her mind, but the defense has built in time that the defendant can testify. So, Chloe Jade asked, what's coming in with the Walk the Dog letter? The first 3 pages. So all of the story about buying or needing to connect the pills to Mexico and the rest of it. I think it's really going to undermine Staking's testimony, because Staking's testimony was line for line the Walk the Dog letter. So I guess it could go both ways, right? The jury could look at Staking's testimony and be like, oh, it's exactly the same as the Walk the Dog letter because that's the truth. Or they could look at Staking's testimony, look at the Walk the Dog letter and be like, oh, we've all gotten on the same page. We've all taken vague notes. So we're all on the same page. It just depends on how the jury sees that testimony. But it will be interesting how the jury sees that. So let's see. Do you think Kouri will pull a Donna Adelson? It's possible. It's possible that she'll get down to it and be like, yeah, no. I think it's very possible that she testifies. We're just going to have to wait and see when we get to the end of it. Lucy asked, how was Bloodworth appointed for the trial? He may just be the most senior trial attorney at the DA's office or the the county prosecutor's office in Summit County. But I imagine in their county, the elected DA chooses because it's a much smaller prosecutor's office than where I worked. But it's, he's a DA or I think they are county attorneys, but he's a prosecutor at the prosecutor's office, and he was assigned to the trial probably from the elected DA because we saw the elected Summit County prosecutor in court. So like the bossy boss, the elected bossy boss was in court, but I wouldn't be surprised if he's one of the most senior trial attorneys in the office. So that's how. It is one of their more significant cases for sure. Let's see. We talked a little bit about what happens if the defense doesn't turn in their motion in time. The judge will be frustrated. I would be very surprised. I would be very surprised if the court did not allow them to make changes if they did not. I think if they submit it close in time, but if they just blow it off entirely, I don't know what'll happen, honestly, because I don't see the judge just saying, you know what, we're not doing any of this. I don't know what he would do, honestly. He's been pretty patient with the defense. He was, by the end of the day today, he was like, So it would be bold. I mean, if they turn it in at 6:05, is that the same thing? If they turn it in at 11 p.m., we're just going to have to wait and see. But Judge M has been patient, but there is a limit to those patience. And they might fuck around and find out with that. T-Bill asked, why isn't the prosecution calling Amy? I don't know that they're not, but it seems that they may not. But I don't know. We're just going to have to wait and see. I'm not quite sure what. I don't know if we will see a few other witnesses before we get to O'Driscoll. So the court today was more patient than I could have been, for sure. Do you think jurors watch trials back at the end? I don't know. I don't know if they'd want to. They might be exhausted. I don't know if you've already gone through that, if you'd want to go through it again. Though I could see jurors being like, okay, this crazy thing happened. I know it was filmed. Can I show you? I could see them showing moments. But I think a lot of jurors just want to move on at the end. But we'll see what happens. Today was just wild, wasn't it? Let's see. I'm going to try. EDB Super Note, I stan. I'm going to go with I stan. I had the Manta and the Nomad. I love my Super Note. It's been fantastic. I've been really happy with it. I like the nibs on the pens. And that has been one of the huge changes for me with the... Emily, you mean the sensory experience is quite important to you? Shocking. It's quite important. I like the nibs on those particular pens. Thank you to everyone who gifted memberships. I'm going to try to wrap through the last couple questions and thank everybody who gifted memberships. You guys gifted so many memberships today. It's incredibly kind. Thank you. And then zoom for the day to go spend some time with the kiddos because it is needed. Let's see. Alexandra said, EDB or Emily, do you think they need to prove how Kouri made Eric ingest the fentanyl? I am very curious to see what all is in Kouri's statements. It is a big part of the state's case. It is a part of the state's case we haven't gotten to yet. It is a circumstantial case, so they're never going to say, oh, Kouri was like holding this to him. But I think there are some very logical and reasonable conclusions that can be drawn from Kouri Richins' statements if they come in as we saw them at pretrial and the evidence that we've already seen. But I saw so much at pretrial that I'm trying to wait to see if what comes in evidence comes in the same way it came in at pretrial, because I know what some of those statements are. And so it's difficult for me to parse that out of my brain. So I'm waiting to see how some of those statements come in, because there will be more context where it's going to be it came in orally. It was orally ingested. I don't think, maybe there are questions about that, but after the coroner, both coroners' testimony, I don't have questions that was ingested orally. How it was ingested orally, I think, becomes the bigger question. And some of Kouri Richins' statements will give interest to that. So we will see. But I do think that there's a couple comments about the judge needing 5 minutes to scream into his pillow. The judge went back and looked at the law and took a breath, gave the attorneys a minute to coalesce their arguments so they could present something to him that was useful. Because there were times that the defense was not giving the judge anything helpful and anything that was impactful. And the judge was like trying to pull out the legal arguments from the defense. And that's also kind of wild to see. It's like, can we just? So we're waiting to see. Ali Mama Bear said, EDB, you usually withhold judgment, guilty, not guilty. I mean, I don't pull on guilty, not guilty. I went into this case with a lot more knowledge about this case. I'm waiting to see how the prosecution proves their case. So my own thoughts aside, I'm waiting to see how the prosecution proves this case, but I know a lot more about this case, as I said at the beginning of the case, than I do about others, because we've covered this since the detention hearing in 2023. So there's times where I'm like, I'm waiting to see this come in. I'm waiting to see that come in, because I know what is going to come in. So my brain is already connecting some of those dots to evidence that we haven't seen yet, that I am waiting to see, which is why I'm just like, yeah, I'm waiting to see how the prosecution proves it and what comes in, because we know some stuff that's not going to come in, and we know some stuff that is going to come in. So I'm just waiting to see. And what's been interesting is we've seen some stuff come out in cross that wouldn't have come out in the prosecution's case that I was like, oh, damn. That's interesting. That's very interesting. And the defense has done that a couple times in this. But also, I try not to give spoilers on all of those things, because we have people watching the trial for the first time with us without any of the pretrial stuff. So I try to give not too much context that might not come in, and try to not give all of the background that we know from pretrial motions, because there is so much evidence left to come in. Even though there's not that many witnesses left, there's a lot of information left. And this case was always going to weigh heavily on Kouri's statements and the consciousness of guilt evidence. It was always going to be a very big part of this case. So where you can poke at different things, it'll be interesting to see how we, what the case looks like at the end of the prosecution's case, and then what the case looks like at the end of the defense case. Because if the defense keeps going like this, they might step in some of their own stuff. And if Kouri testifies, it's all going to come down to what Kouri says. The rest of it might not matter if Kouri testifies, a la Banfield. It's just gonna be a wash. So and again, the jury doesn't vote until the end, though it is on the prosecution to prove their case, but that includes their rebuttal. So you guys can be wherever you're at. If the prosecution proved it, didn't prove it, what information you want to see, what information you don't want to see, what you want more questions about. Why does Bryce not have any fucking pants? Where is Amy in the incident over the safe and the rest of it? It's completely fair. The jury's asked to keep an open mind until the very end of the case. It's fair to do that too. It's fair to be like, I still have questions. Completely fair. It's completely fair. And wait and see how it unfolds. It's fair. Because it's also okay to be like, vibes are this, but I don't know if I have enough evidence to get there. Fair. Completely fair. To be like, these are questions I want to see answered. Completely fair. It's a wild, wild day. Wild day in court. So when we get to what's going to happen tomorrow, who knows? If anything, I said, damn it, I said at the beginning of this case, one of the things I was looking forward to is how just normal this case had proceeded in the pretrial motions. And then we got into trial and it was like, bet. Normal, you say? Haha. It will not be. The fuck it will be. And we had seen this case had seemed so orderly moving forward. And then it just went whoop, just completely the other direction. And now we're at the point where when anybody other than Ramos on the defense side opens their mouth, I'm like, can we just get Ramos back, please? I feel like we've had a full, we've come back around. And now we're just like, can we just get Ramos back? Bring back Ramos. Please. We would like him to clean this up. It has been wheels off. Just the trial has just come off the tracks, jumped the shark, and the rest of it. A lot of you are asking, how long can this trial go till? Well, the jury has been told through March 27th. It's March 10th. March 27th. They've been told through March 27th. So Ramos had a rough day one, but since then, much better than day one. And you know what? I don't feel nearly as gaslit by Ramos. There can be some theatrics, but I'll take the theatrics over the gaslighting any day of the week. I will take the theatrics over the gaslighting. I will. The gaslighting pisses me off. Really just hate it. Leonards, today is the day to either catch up on days of trial, go explore the walk the dog letter, or don't. Catch up on the other shit you need to do because we are back in trial with maybe a full day tomorrow. If you want to know what time we're starting tomorrow, you're going to need the Leonard app, because if they come back into court and then take like an hour-long break, I am going to wait. I'm going to wait it out until they're back because I love that Zoom room, and mornings aren't your girl's favorite. So I'm going to, if there's a giant gap of time tomorrow because the jury's not coming in until the afternoon, we're going to just take that gap of time too. And then we're going to just Zoom together. So the best way to know is the Leonard app. I will update the time when I set the time for stream after we see what happens tonight. I will update that time there so it might get pushed back. We will leave members chat open so you guys can just chat, but we might be pushing things back in real time so we have some Zoom room and we can spend a little time with the kiddos in the morning. So that's the thought on this end, little scheduling note. But the long and short of that is make sure you have the Leonard app, and then we'll know when you know. And I'll keep you posted on what happens tonight. Because oh boy, I'm gonna be clocking that docket immediately. And if it's filed publicly, I bet you it's gonna be under seal. But if it's filed publicly, I'll let you know what it says. I'll keep you posted. Get some shit done today. We've got court again tomorrow. Leonards, thank you for being here. Thank you for making this the number one place to watch live trials. I love being here with y'all. Thank you for no spoilers, those of you that can still chat today. For all of you that were like, it was only a baby spoiler. The I'm just a baby defense is not going to work. I'm just a baby. No. I'll see you tomorrow with no spoilers. You guys have a good night. All right. I think I was going to just But I think that this is what we just need to leave on today.
Why is no one ready?
That's where we are today. I'll see you guys tomorrow. Thank you for joining me. Make sure you don't miss a live stream or any of the updates on the cases that you care about most with the Lawnerd app at lawnerdapp.com. It's a free download on iOS and Android, so I can keep you in the loop. Because you never know when something's going to pop off. Thanks for being here, and thanks for being a Lawnerd.